We'll start with any announcements from staff.
No announcements today. Thank you.
Okay. Thank you. Moving to roll call of board members. We'll start with Joel and we'll move over to staff as well.
Joel Mazellis. Craig Allen.
Andy Ball.
Catherine Morsani.
Paul Wolosinski.
Griffin Kearns.
Kurt Euler.
Savannah Glantz.
And we're hopefully expecting more board member here before we hear the variants coming up. So we'll note that for board members. Next, we have approval of meeting minutes. We had a couple of those minutes emailed out from staff to board members. You want to review which meetings those were, Griffin, again?
Those were for the two previous special meetings that occurred on December 11th.
Double header, 2 meetings in one day. That was fun. Are there any comments, any edits, any motions related to that, those 2 sets of minutes?
Motion to accept.
There's a motion to adopt both of those. Is there a second?
Second.
Any opposed? All those in favor, please raise your hand.
Aye.
Aye. That passes. Moving to disclosure of ex parte communications or conflicts of interest. To clarify, we have statute language here. Quasi judicial decision. Any board operating under these provisions, board member must not participate in any vote or a hearing on any quasi-judicial matter in a manner that would violate affected person's constitutional rights to an impartial decision maker. And permissible violations of due process include, but are not limited to, a member having a fixed opinion prior to hearing the matter that is not susceptible to change, undisclosed ex parte communications, a close familial, business, or other associational relationship with an affected person, or a financial interest in the outcome of the matter. And with that clarified, we'll head down the list from Joel and then introduce our new board member as well.
No. No.
No. No.
Just as a reminder, yes, I asked about if, as I would any organization, if they had had a community meeting,
They
And-
contacted you separately and asked about it.
or we discussed it, and that's the extent of that conversation.
And that was on which one again?
The Emma Road.
Emerald. Yeah. Okay. Sounds good. We had a conversation last month about this and cleared that.
That does not sound like a conflict of interest.
Would not qualify.
While I appreciate the disclosure, that does not seem to conflict the
Yeah.
member out of the
As long as we
from voting.
disclose. Anything else?
No.
No. Okay. Thank you so much. Moving to public hearings. First, we'll note that this is a quasi-judicial evidentiary hearing, and that means similar to a court hearing, state law sets specific procedures and rules concerning how this board must make its decisions. The board's discretion is limited. We must base our decision upon competent, relevant, and substantial evidence in the record. Our decisions must be constrained by the standards in the zoning ordinance and based on the facts presented. If you'll be speaking as a witness today, please focus on the facts and the standards and not personal preference or opinion. General witness testimony is limited to facts and not opinions. It's taken at the end of the hearing when it concludes for the board's discretion. For certain topics, this board does need to hear opinion testimony from expert witnesses. Those topics include projections about impacts on property values, projections about impacts of increased traffic, and individuals providing expert testimony must be qualified as experts and provide the factual evidence upon which they base their expert opinion for the board to consider that. As a reminder, we'll note that board member, staff, audience should make sure their cell phones are silent or on do not disturb mode, if possible. Moving to our cases this month. First on the list is the Emma Road Townhomes. We will hear from staff on this. We want to consider. There's been a request to push this to the next meeting. Yes.
Yeah, Mr. Suggs, are you here on behalf of the applicant?
I am. Warren Suggs, Civil Design Concepts. We're the civil engineer on the Emma Road project, and we would respectfully ask for a continuance to February to give us some more time to continue to speak with the neighbors.
That's great. Is 1 month enough, you think?
Yes.
Okay. Let's, any questions or you want to act on that?
I make a motion to continue.
Well, that motion is to continue to the regularly scheduled February meeting. There's a second as well. All those in favor, please say aye.
Aye.
Any opposed, nay? That motion passes.
Thank you
so much. And with the board's input here and agreement we will look at a modified schedule from what's listed here. We're expected to hear some longer period of testimony here on ZPH 00036 SCM special use permit today. So we want to see if we can move the Hendrickson variance up before that case. Is that agreeable for the board?
Agreed.
And applicants agree as well on that one? Yeah. Okay. So it's time we'll call Jason. Jason, introduce him? No, Jason's not here. Okay. ZPH 2024-00032, the Hendrickson variance is continued from the December meeting. And the board did receive an email with links to the video from last month in case those members weren't in attendance.
All right. Please raise your right hand and state your name.
Savannah Glantz.
Do you swear or affirm to tell the truth and nothing but the truth?
Yes.
Thank you.
So yes, Jay is out today, so I'll provide a brief overview again. This is for ZPH 2024-00032 Hendrickson variance. The property is located at 5 Margaret Lane and it's zoned R2. The applicant has applied for a variance to the zoning ordinance of Buncombe County to allow the right-of-way setback of a dwelling unit to be 1 foot instead of 20, which is a difference of 19 feet. And the request is being made to allow the installation of a septic system, and I will defer to the applicant at this time.
Sounds good. Welcome back, y'all. Welcome back. How are you?
Thank you.
Good.
Please raise your right hand and state your name.
Brooke Hendrickson.
Do you swear or affirm to tell the truth and nothing but the truth?
I do.
Thank you.
Thank you.
Yeah, feel free to update us on anything that's happened in the past month.
Yeah, so we have.
Yeah, I'll be pulling up a PowerPoint for her, so if you'll give me just one quick
Sure.
moment. Thank you.
While she's doing that, thank you again for giving us the chance to get more information. That was really helpful for us, and I hope that this PowerPoint will clarify some of the questions that you guys had last time we talked.
That's great.
Okay. Thanks, Savannah, for assisting. Okay, so just a couple of things about the property. You'll see it's 5 Margaret Lane. We also, when we purchased it, it was written as 201 Patriots, but just so you know, you may see both addresses, but we're talking about the same property here. It's zoned R1, which permits a maximum of 2 dwelling units. It does not have access to city sewer or water, so therefore it requires a septic system and a well. It's just over 3/4 of an acre, and it was platted in 2008. Therefore, it's considered a non-conforming lot. It is also partially located in the steep slope overlay, and it contains a natural swale on the eastern side of the property. Next slide. We're working on it, sorry. Oh. So as you can see from the site plan here, the western side of the property, which has a private road on that side, which is Margaret Lane, has a 25-foot right-of-way. It also requires a 20-foot setback. So that places the building area 45 feet from the property line and 40 feet from the edge of Margaret Lane. Next slide. Sorry, what's?
We are having technical difficulties, so
Okay.
apologize, board.
Okay, no problem. Okay. This is just a closer view of what I was just explaining. So the property boundary is on the very, very furthest left line. That is in the middle of Margaret Lane. Margaret Lane is a 10-foot wide road. So there's 5 feet on the other side and 5 feet on our side of the property line. And then there's 20 more feet from the right of way and then another 20 feet, which is the setback. So you can see how that's squeezing the amount of buildable space on that western side of the property. Next slide, please.
And to clarify, Margaret Lane goes further up the hill. There are other
It does.
residences
There's
above
one
us.
other property up there. Oh, no.
If it's okay with the board, I'm just going to leave it on this and not go slideshow because I think that's the issue.
Yeah,
Okay.
that's
Thank
fine.
you.
As long as you guys can see that. Okay. So let's see. The next slide. So our request would reduce the setback along the western side of the property from 20 feet to 1 foot. That would leave the right-of-way, 25-foot right-of-way in place. It would put the beginning of the building area 26 feet from the property line and 21 feet from the edge of the road. It's just giving us a little more room to work with here. Next slide. Oh, dang. Okay. Okay. Great, thanks. Can you back it up back it up one more? There you go. And so this is the site plan with that reduced setback. So you can see that the right-of-way is still pushing the buildable area. Again, it's 26 feet from the property boundary, 21 feet from the edge of the road. Next slide, thank you. So we're requesting this variance in order to accommodate the installation of a septic system. Next slide. So the required 20-foot setback in combination with the 25-foot right-of-way reduces the amount of buildable area. The size, shape, and topography of the lot further reduce the buildable area. If sewer or city water were available to this property, we could build the project while meeting the current setback requirements. There's an MSD connection right next door to us. Unfortunately, it's just we're not close enough to connect to MSD. So flexibility and setback regulations would remedy this situation while ensuring compliance with other health and safety regulations. So the hardship is based on the size, the shape, and topography of the property. As I mentioned before, this was platted in 2008. It's considered non-conforming to Buncombe County minimum size standards that were enacted in 2009. It's also irregularly shaped. You can see like on the right side of the screen, there's some lots that are similar size to ours, but those are all square and rectangles, obviously trying to fit a rectangle size home in this shape where the sides begin to narrow on that side is just difficult. Next slide. It's also partially located in the steep slope overlays, so that renders the northern part of the lot unusable for construction. There's also a natural swale on the eastern side of the lot, and you can see that here through the topographical map. That swale is between 10 and 15 feet wide, and it runs through the entire lot north to south. So we spoke with Stuart Black, who we've been working with for our septic permit. He's saying that the septic requires a minimum of 15 feet setback from that swell. And since it's 10 to 15 feet wide in places, that creates a 30 to 45 foot wide swath of unusable space on the eastern portion of the lot. And this is just an email saying that from him. So the result is we have a 20-foot setback on top of a 25-foot right-of-way on the western end of the property that's reducing the amount of buildable space on that side on a lot that's already considered small based on current lot size standards. That, in combination with the natural swell in the eastern half of the lot and steep slopes throughout the northern portion of the lot, leave no space for a septic system. And we don't believe that these are self-created. These are due to the unique physical characteristics of the land. These are inherent and beyond our control. We also haven't taken any actions to aggravate the existing issues or made any improvements or modifications. And we intend to make reasonable use of the property under the constraints imposed by the physical characteristics and the zoning rules. Sorry, nervous. This balances our rights as property owners to reasonably use our land with the intent of zoning regulations and the interest of the community. Approving the variance doesn't grant us any special privilege. The adjustment just allows us to use the property in a manner that's consistent with Buncombe County zoning regulations and neighboring properties. The purpose of a setback, again, is to ensure adequate spacing for safety, privacy, and functionality. If approved, the buildable area would again begin 26 feet from the property line and 21 feet from the edge of Margaret Lane. This exceeds the standard 20-foot setback requirement. So therefore, it still aligns with Buncombe County's goals as it accommodates a necessary septic system without compromising public health or safety. So in summary, this variance achieves substantial justice by ensuring fair and reasonable use of the property. It addresses the unique challenges and hardships on the land without compromising the community's welfare. It also has no adverse impact on others, and it applies the law in a manner that's consistent with its spirit and intent. Excuse me. There was a couple of questions that got brought up during the last meeting, so I wanted to address those as well. So there was a question about due diligence. We thoroughly investigated this property in terms of usability, value, and compliance before purchasing it in 2023. Next slide, please. So here's one of many communications that we had with Buncombe County Planning and Development staff prior to purchasing the property to make sure that we could do what we were planning to do with it. This is another thing we did before purchasing the property. We worked with an engineer who placed our primary residence in an ADU. We were trying to make sure with the setbacks and with the steep slope and with all of these things, can we fit this, what we want to fit on the property? And he was able to figure that out for us. So then we closed in December 2023. We began working with Mr. Black in March of 2024. We finally submitted a site plan review in August of 2024. That's when it was brought to our attention that the setback plus right-of-way requirement wasn't being considered. So then we went back to Stewart and worked and reworked the location of the house, the ADU, the septic, the well, and eventually we were told that we were out of options. So while we understand that a failure to conduct due diligence could lead to unexpected obstacles, we believe it's unreasonable to expect us and other buyers to foresee or resolve every potential issue, especially those related to the size, shape, or topography that only become apparent after a detailed planning or zoning reviews, which is what happened to us in this case. So we have exhausted all of the options and we're applying this variance as a last resort. One of the questions you guys had was, why 19 feet? Why can't we be more specific? So we reached out to Mr. Black after our last variance meeting and asked this, and he just said, basically having the most amount of space is going to give us the most flexibility. It's a lot of back and forth. He comes out to measure, surveyor moves the house, he comes out to measure again, surveyor moves the house. So he's just saying that asking the maximum is going to give us the most flexibility and not have to come back before the board and ask for another variance if we're off. He also verbally told us that we're not likely to use that entire amount of space. We just don't know exactly how much it'll be. Next slide, thank you. Oh, another question you guys had was placement of the ADU. We again went to Mr. Black and asked, like, is this in the best possible place? And this email confirms that. He says that the eastern side of the lot is not suitable for a septic system due to its shape, size, and shallow soils. This is on the other side of the swale, whereas the western side of the lot is not suitable for the ADU due to setback and other spacing requirements. So you guys also wanted to see like the layout of how this would all go down. So we asked if Mr. Black could create an improvement permit that shows the proposed location of everything. And so that's what we have here. There were questions about character of the neighborhood or what we were doing. This is a rendering of the house we're building. It's a 3-bedroom, 2-bathroom home, 1,300 square feet. Next slide. So 1,300 square foot home with an eventual 5-year plan, ADU, 400 square feet. I just looked at the average of 6 homes in the immediate area around us, the largest one being 2,700 square feet, the smallest one being around 1,100 square feet. We're right in the middle. So I don't feel like this is out of character, both in its style and size. So we believe this is a modest and reasonable use of the property. This variance would allow for growth and sustainable development. There's no impact to others. It also ensures compliance with environmental and zoning regulations. We're trying to think ahead and not ask for forgiveness later. We're asking for permission now. And it allows us to have long-term investment in our community. You know, we plan to live here and make this our forever home. So, thank you.
Thank you for that great presentation. Do you happen to have a copy, or is there a copy the staff can provide of that improvement permit
Yes.
to look at the schematic there?
Would you like me to pull up that septic slide again for you all to look at?
If you would, that would be great. Maybe zoom in on that.
I can also print that out and just give you all a copy if you'll hang on for a moment.
That's been the best, I think.
Okay. And very briefly, I was going to close out of this. Do you still need the slideshow?
Nope.
Okay.
And is there anything that's changed since last month on the capacity of the house, the size of the house, the fact that there's an ADU and not a 4-3 permit for the house alone, putting it in the basement? Nothing's changed.
Nothing else has changed.
Okay. So my question is, why wouldn't you consider other options? If you know that we had so much difficulty coming to an agreement last month, why wouldn't you come and present us other options instead of the same option?
I think that the only difficulty last month was there was confusion over why the specifics. And so I don't know if there was necessarily disagreement, but there are a lot of questions. And so there's not other options as far as we've explored. Again, this is a last resort for us to come here. And we were hoping that answering the questions that were raised last time would help.
I think on the permit we're going to get printout of and look at here. I'm kind of trying to get at the answer to a question we asked last month, which was because you have an ADU and a single family home, both on the property of this size and topography, and a 4.3 build out for all of that, the size septic system, if you didn't have the ADU there, could that be reduced or moved to the east, I guess, to the right, to account for a smaller footprint if the ADU weren't there?
That's so, as Mr. Black explained, this is an email that I provided to you guys. I asked specifically about this, and I'll just read you he says, your chosen ADU location will probably have less impact than almost anywhere else. We will need all the space we can get on the western end of the lot to fit the septic system and the well. There are also well setbacks from other structures to consider. This would make the western end of the lot a poor location for the ADU. Also, the area the proposed ADU is located in between the swale and the lot lines is relatively small and odd-shaped with shallower soils, which would make it a poor location for the septic system.
So on that answer, then that question and answer there, that was
So moving the ADUs into not, whether it's there or not, that area is not usable from the septic system perspective at all.
Gotcha. Okay. So did you ask and did he comment on whether if you needed a 3.2, if you had a 3.2 set up for a smaller system?
We
and
didn't.
have the ADU, for instance, if you went and applied for that, would there be room without the variance for a 3.2?
We didn't, because we're not building a 3.2. It's not our project.
Those are the other options that the board's been talking about last month and this month, is if the lot can't fit a 4.3 or an ADU in addition to the house separately, typically people automatically would reduce their footprint of what they're building. So that's what we're talking about.
My question, though, is what is the variance process for, if not for making adjustments? Couldn't you just tell every person who's applying for a variance to build something different or smaller?
Yes. That's what the code is designed to do.
So that comes to my question is why can't you just build in the rules? And you've presented not one option that said, you know what, if you did not grant this to us, here's how we would think about it differently. Here's how we could fit it differently.
My understanding is that we're trying to build what we're trying to build within the rules, and we're, again, like I just am confused of why even have a process I'm just confused of why this process would even exist if it doesn't allow flexibility when people are trying to build something that would otherwise fit.
But it doesn't fit. And that's the other thing is you're also trying to compare, the homes that you did the comparison to, how many acres per square foot, with you saying that, oh, this fits in. But what I heard from last month, because I wasn't here, but I watched the video, is that most of the lot sizes, I think, were 1.5 acres instead of the 0.77 that you are. And so I'm not understanding why you're trying to fit a 1.5 acre situation into a 0.77 acre
I think that there's
space.
plenty of examples of lots that have this size home on it.
In your neighborhood?
Yes. Part of what's going on here, again, it's the shape. It's an irregular shape. We have a natural swell that is taking up 45 feet in the middle of the eastern half of this property that is not, we can't build on that. And we didn't create that. That was a natural occurring thing.
But you're trying to build, you're choosing to build something that's not going to fit the space. And
But
so
isn't
that's
that what
I'm really trying to understand is why are you so stuck on that why? to
Because this
Andy's
is
point,
what we're,
why can't you think about not having the ADU and just going with what this land will fit? Because what we have to think about is what's going to be fair for all Buncombe County residents, not just you, but all residents and anyone with a variance. Usually when they ask for a variance, they say, here's situation A, here's what we could do situation B. And for the last 2 months, I'm not hearing any options.
Hold on
It's
one
just one answer is we want what we want.
we also want to be treated fairly. And if you watch last month's meeting, you'll notice that there was another variance request asking to build a large garage. That was approved unanimously. You all could have said, just
And I
build a
wasn't
small,
here for
I
that.
know, I'm
So
just
I would
saying,
have had the same
I
conversation.
am just saying, that was approved unanimously. We just want equal application of the law. You guys could have in that moment said, just build a smaller garage. You don't need this large of a garage.
Okay.
But
so
no one
I can't
did.
consider that because I'm focused
I'm
on
not asking you to
and your
consider, but you were bringing
situation.
up last month's meeting and you were talking about equal, treating
No,
people
I'm talking
equally.
about your situation. I was focused
I'm
just
talking
on
about it
you.
as well. We're asking for the same thing.
Okay. So what I have a challenge with is why can't you and your designers design within the rules? And then what about options to help us fit in the rules? And then how do we be fair for all concerned in Buncombe County?
I just don't understand. Again, like if is not like a variance request based on the project at hand. I didn't see when I was looking at the general statute anything about, well, if you could just change and completely change your project, then
Andy asked you if you could change your project.
I know, but what I'm saying is I don't know if that's a fair thing to ask because we're not asking for something else. We're asking for this.
Okay.
My understanding, and correct me if you think I'm misstating this or that this is incorrect in your opinion, the ADU is the reason you can't fit it all on the so hold on. The ADU is the reason you can't fit it on the property. If you had the ADU in the basement, for instance, and you still needed a 4.3 capacity for the property, you would be able to fit the 4.3 in the existing footprint in the
No,
basement.
sir,
Yes.
that is not correct.
Okay.
So imagine the ADU is not there.
Yeah.
And instead we
You can't
have,
fit space at all because
we have a 3-2 house with
Right.
an unfinished basement that we would like to one day finish. So rather than building that out and that now we have a 4.3,
okay.
we still are dealing with the same issue.
No, I get that. I get the answer totally. And I understand now. The goal is to build the 3.2 with the unfinished basement with future capacity and the ADU.
We're trying to,
0.77 acre lot
yes,
with these conditions.
yes, sir.
And I do not still see the hardship in this case because the idea that you would come forward wanting to build the ADU as part of this on a lot where it doesn't fit because of all these regulations, we have to establish your unique situation and the reason your particular situation does not fit everybody else in the neighborhood or else in the county. Other people aren't coming to us for permits or variances to fit an ADU on their property. Because it doesn't fit.
Chairman Ball, before you all, I would think that you might want to ask the applicant if there are other lots in the neighborhood that have accessory dwelling units on them.
On a
to-
0.77
there are.
acre?
I mean, once again, we don't really get into what the lot size is. It's what the reasonable use is for the property. And in this zoning district, the reasonable use is a single family home. And Savannah, please correct me if I'm wrong, but you are also allowed to have an accessory dwelling unit. That is not, they are not going, I guess what I'm trying to say is that is not, the request is not doing something outside of what the current zoning ordinance allows. It's a question about how do you fit that all on the lot in question. And I guess what I would want to know is whether there are other instead of getting hung up on that, are there other units or other houses in the neighborhood that also have accessory dwelling units? And then try to look at, is the lot, the topography and the issues, is that creating issues for them in developing it, as opposed to focusing on, whether there are other designs, because yeah, they could probably plop a tiny home on there, but that's outside. I don't think that's when they're talking about reasonable use of the property. I think the question is whether are they able to use the property like anybody else would in the same zoning district.
The other homes and properties would have already been built, of course, and would have complied with the setbacks. because
Well,
the
it's
lot size
quite
was big enough.
possible, but if you all recall, like in other things, depending on the lot, depending on the lot, you might be able to get something, you may be able to fit an ADU in there and you may not. So that's kind of the thing. And I guess the question is what they're asking unreasonable?
And I think under those guidelines and that guidance, I think my answer would be it may not be reasonable because the lot is too small.
I just want to say again
Yeah.
that the ADU, the location of it, that's not affecting the size or anything else associated with the septic field. Nothing can be built or done on that side regarding septic. And that is directly from Stuart Black. Nothing.
Do you have an email to that effect?
Yes,
here?
you have,
I've
you
got a
have
schematic
all,
from him here.
you have all of the emails. And again,
I'm sorry. So you're
I'll
saying
read it to you. So the existing natural swale requires a minimum setback of 15 feet to the septic system area and the repair area. The swale itself is between 10 and 15 feet wide in places. This makes a 30 to 45 foot wide swath of unusable area through that portion of the lot. He can't start the repair area on one side, cross the swale, and use that last little bit.
Yeah, I don't think you can use that at all.
No.
If you built a 3-2 house with the unfinished basement and no ADU, could you fit a 3-2 septic, a smaller system?
We didn't ask because that's not what we're building.
We asked it last month of you, and so that's why I'm bringing it up again. Yeah. We've sworn in. Are we still good?
I can swear you in now. Please raise your right hand and state your name.
James Hendrickson.
Do you swear or affirm to tell the truth and nothing but the truth?
I do.
Thanks, James.
Yeah. The reason we're building this house is because this is somewhere we're planning to live for, decades and build a family. Yeah, we could build a 2-bedroom house and an ADU, but that's just not going to be something that we are able to grow and build. What we would end up doing is probably just selling it and or building 2 smaller places to rent as an investment property, and that's not what we're looking to do. We're the standard setback is 20 feet. We're going to be at least 21 feet and hopefully more. We're going to be as far from the road as we possibly can. So I'm just not sure it seems like we're in the spirit of the setbacks for all of Buncombe County. I feel like the point of the board is for this exact sort of situation where it's we're not building a massive house where we're staying within over 20 feet, which if you look in the neighborhood, it's only required, 20-foot setback is required on most of the lots. We just happen to have the private road going up behind us. So I feel like it's a pretty reasonable ask.
Yeah, one question I have, because I'm starting to get a little bit confused now. If you built the same size house that you want to build
Yes.
and you did not build the ADU, would you need a variance or not?
We don't know because we didn't ask. That's not what we're trying to build. The entire thing that we're asking.
It doesn't, that should be an easy question.
Yeah.
It should be like a really easy answer.
Yeah. If we were to build a 3-bedroom with no ADU, you're saying.
If you built the same size house that you're going to build,
Yeah.
and you
So
didn't build the ADU on the
Yeah,
other side of the
so,
property, okay,
well,
could you move the house back?
yeah. Well, we wouldn't be able to move. We wouldn't be able to move the house. The question is, do we have the right to build 2 in the zoning to
No,
build
that's,
2
no, that isn't the
dwellings?
question.
Yeah.
That is not the question.
Hold on. Can we please keep some decorum and let's ask a question and have answer?
Full
And
question
no-
and
I
full
apologize.
answers.
Thank you.
Thank you. Thank you, y'all. Okay, continue, please. Yeah.
Again, it's that placement of an ADU over there has nothing to do with the septic field and repair area. It can't be used.
So according to the septic contractor, you cannot build a 3-2.
According
with a
to
basement
sewer
and a
back-
and a 3-2 septic system next to it.
Environmental health inspector working at the county, yes.
So you have to make that the house smaller than 3-2.
We haven't even,
We wouldn't
we
be
It
able
is
to
the
do
old
a
house.
explored it.
We wouldn't be able to do a four.
Yeah.
Four
The
bedroom.
don't
bedroom
know.
septic's for four bedrooms.
But
Yeah.
That's that.
And if it were 3, it would need a smaller repair area, et cetera, smaller. footprint.
we haven't even looked into it
Okay.
again
If
because
you'd like to look in, my opinion would be, if you'd like to look into it going forward, that would be my recommendation if I were y'all, is to look into.
I just want to
downsizing
ask one
of
more
it.
time is, again, like, just like with the variance that was before us last meeting, why not just tell this
Totally
person
different
to
from the
build something
variance.
smaller?
It's totally different from the
But,
variance.
but I reviewed several variances over the last few years, and in every case, you could just literally tell someone to build something different or something smaller.
We changed a rear setback on that case to a smaller footprint to decrease the setback, so a
Right.
garage could be used.
Exactly. I know, but you could have
Where
just
a
said,
garage was standing
build a
previously.
smaller garage. But instead,
We didn't say anything about the size of the
that
garage.
question got brought up
The size
during
of
the
the garage
meeting.
was not
It got
under
brought up during the meeting.
consideration.
Someone said, why can't you guys just build a smaller garage? And he said, I have a really big truck.
Yeah, but then we realized we weren't making a judgment on the size of the garage. We're making a judgment on the setback only. That's all the board's action was.
That's
Which is
all
what
that
it
we're
would be
asking
here.
for you to do here.
But it's not a garage, it's an ADU.
But why does,
And it's
it's
changing
not,
the septic parameters.
it
which
is
you need.
not changing the septic parameters. And it's not, why does it matter
You're
whether
gonna-
it's a garage or a primary
I'm
residence or an
going off your, I'm
ADU?
going off your testimony today. You said that if you downsize the house, if you got rid of the ADU as part of the plan, and you downsize the house, and you said you got a 3-2 house you're building with the basements unfinished, you would not be able to build a 4-bedroom septic on that
Yeah.
lot.
Right, because it has nothing to do with the ADU. Has nothing to do with that.
It has to do that there might be a 4th bedroom in the basement in the future.
Exactly.
Well, I'm all set with my questions, but please, any other questions? Yes. Okay. Is anyone? Yeah, please do.
At the conclusion, as a part of the dialogue last go around, a lot of reference to Mr. Black.
Mhm.
And I think we suggested that his testimony would be of great value. Yet he's not testifying. And is there an explanation for that?
Yeah, he was not willing to do that. He works for the county. He's kind of was
I'm
shocked.
checking to see if I can get somebody from environmental health
He was surprised
Here.
that it was this
to
Much
answer
of
this
a-
question.
kerfuddle. He couldn't believe. So that's why, after we spoke with him and explained how this meeting went and explained your questions, I said, I'm going to ask you these same questions and I'll ask that you just email me your responses, please, so that I have something to give to the board. And I've shared that with you all.
What would be your reaction to the board's possible decision to continue this meeting to allow Mr. Black, which was the
That would be
original
fine.
objective of this committee, to come forth and answer some of these technical questions regarding
Miss-
the placement of a septic system?
If Mr. Black, I can either work if that is what the board would like to hear. I can either, I'm trying to get, unfortunately, nobody isn't there. Septic's busy right now with that. But we can get somebody here. The board also has the power to subpoena somebody should they need to be here. If that's something that you all want. I apologize. I wish someone would have let me know and I would have worked on getting somebody here had I
So
known.
Kurt, I don't feel like I need it.
That's up to you all. I'm just
I
offering
mean, I'm
that.
just doing a little straw poll right here. Catherine does not need it. Anybody else feel that they? need
So
it?
I would probably
I'd
look,
like to say to the chair, I don't believe there's a unanimous opinion based upon the dialogue of last month's and the dialogue that you have been engaged in this month. So with the desire to hopefully come to a unanimous decision, I think that we have some unanswered questions that our septic expert could potentially resolve.
I'm certainly open to having.
Because what
to that
I'm
process.
hearing, I sense is not what you're hearing. Regardless of the decision, I'm hearing something different than how I react to what I sense
Ah,
you're hearing.
okay. Yeah, and to be clear, the board doesn't have to unanimously agree on anything. They can vote and that'll be the decision. But we don't want to deny anybody's.
Right, but if
No.
there, in a
ability to
variance, if
do
there were
that.
two
But I
no,
also don't need to hear, none of what we've talked about today or last hearing, the steward would not be able to enlighten me on any of that. Because it's,
And
but I'm just one member, so Joel.
Yeah, I kind of feel the same way. I mean, I'm not a septic authority, even though my last two houses have had septic, okay? And try to build a new well. So I know a little bit about septics and your limitations. So, I would like to see a continuance and get someone from the county here to speak,
Yeah.
okay? I mean, you just said that he's unwilling to come speak.
We just
Well-
asked if he would, and he said, why don't I send you guys an email answering these questions, and would that be sufficient? And I said, I assume so.
Well,
If he, I mean, we would love to have him here too, because we're not experts on this stuff either, and would love to have someone be able to.
And I think that we need somebody who cannot cross-examine an email.
That's right. So that we have at least two members that would like to hear that. So Kirk, would your recommendation be that you continue to try to get in touch today?
oh, I
With
will
somebody before?
definitely get in touch with Mr. Black and make sure that he is here. I think the question is whether the applicant wants to ask for a continuance at this point in time.
Yes, please.
And may I quickly, board, if it's okay with you, one thing that I keep hearing brought up is an example of last meeting with a variance with a garage and how this is not an accessory structure, it's a primary. There was an instance of another variance where it was a home, which, what was the square footage of what you're asking for again?
A reduction of the setback.
The square footage of your home, I apologize.
1,300 square.
1,300, okay. So there was a variance request, the Walker variance actually, where it's a 2,600 square foot home and they asked for a setback reduction from 20 foot to really 0 feet. And that's a 2,600 square foot home. And I just want to caution the board that at that time, I believe it was because of slope, but at the same time, based on the site plan I'm looking at, it may have been that, could they have reduced the footprint of the home? I don't know if that was even brought up. So I would like to bring that up as an example of this is a home asking for a setback as well.
Do you remember whether that Walker variance, whether that one had an ADU proposed or had a detached garage or anything like that aside from the footprint of the home?
I can look into it, but I
As long
don't.
as we're bringing it up, yeah. No. Okay. So is it and just make sure it's not possible and not reasonable to get a member from staff.
No, I actually emailed, Stuart's not available. I actually emailed or tried to text. I texted with his supervisor, who's the head of the environmental health, doing that. He is out in the field right now and unable to do that. But I am happy to that if there is a continuance till next month, I will have somebody from environmental health here and able to speak on this topic if that.
So along that, has there been anybody else other than Mr. Black who has been involved in this?
It's just us, our builder, the surveyor, and Mr.
For
Black.
the sake of the county's time, and why would we want to have another person spend the time to gather all of the knowledge and information that exists with Mr. Black?
Well, I was thinking that normally the supervisor can, pretty much testify on what, because they're usually up to date as to what staff is doing. Yeah, my preference would be to have Mr. Black here. The only reason I contacted his supervisor is just in case he was in the he could be in this very building.
Understood.
And if he was able to come here and help us out, try to resolve this today.
One question that I have for the board before we vote on this, or before any decisions made. If Mr. Black were here, what question or questions would we ask him that we don't already know the answer to?
I think I would want to have a little bit of discussion on this so that the applicant knows this as well. Yeah. Is there
Plus,
anything from those?
whatever we have today is basically hearsay versus what came from Mr. Black. We want the source.
The emails are third party
Like,
and total
not-
hearsay.
It should be him and not a.
And it's her interpretation and reading of what an email may or may not have said.
Well, he wrote the email,
He
right?
wrote the
Yeah, but we
email.
don't have
He
a
wrote
copy
the
of it.
email.
He's reading
You have
it.
copies of all of the emails.
let's move forward. We got an idea. We've got a couple folks who are ready to proceed and a couple folks who would like to hear from some county staff. So you want to discuss whether
Well, Mr.
what's
Chair,
appropriate first?
is it not appropriate for the board members to have discussion amongst themselves?
Yes.
Yeah.
And we haven't had that yet.
That sounds about
Yep.
it.
And so, I've had opinions at one point, but subject to the
Yes.
discussion amongst board members,
Okay.
I have come to a different conclusion. And I should trust and hope that the council or the board members here would go into this next phase with the same approach,
Sure.
not be
on that-
set on an opinion.
On that note, let's ask if there are any other members of the public here just to assert standing in the case or to speak as a witness, either one.
I saw a finger back
Standing or
there.
witness. Witness, yeah.
I'm sorry, you asking for witness?
Witnesses, yeah. Public testimony on this one. Yeah, if you would like to, yeah. Yeah, on this case.
Yes.
Yeah. Please come forward.
And Mr. Chair, going back to that question about the ADU or garage.
On the
So,
Walker variance.
On the Walker variance, they didn't ask for it. And again, I may be misinterpreting how the board is asking this question with septic and size. The home that the Walker variance asked for was a 2,600 about square foot home. And these applicants are asking for a 1,300 square foot home and a 400 square foot ADU, which is still less than what the Walker gentleman proposed for just his home.
And as far as we can tell.
Yeah. How big was the lot? How many acres?
You'll have to bear with me. I have to look that up as well.
I'm trying to get to apples comparison, not just, yeah, there's a building and ADU request.
No, I think the question would be is whether a 1,700, what's the septic system required for 1,700 foot or 1,700 square foot residence, right? So if they break it up, let's say they have a 1,300 main house and a 400 foot ADU, that's one of the questions I think that you would want to know the answer to.
0.33 acres.
City or county? Assume county.
Yes, county,
There's
yeah.
no setbacks, yeah.
Yeah, so 0.33 acres, and they also had that 20/10/20 setback.
And I do recall when we discussed this last month, we all had an agreement that variances do not set precedent. Variance by its very
It's always
definition
Yes.
Yeah.
is a unique decision based upon the unique characteristics of the case being presented.
Yes.
So it
It's a
has no
variance,
bearing.
Right, Greg? That's what variance means.
Yeah. Do we want to hear the witnesses?
Please.
Please raise your right hand and state your name.
Graham Gidley,
You swear or affirm to tell the truth and nothing but the truth.
I do.
Thank you.
Thank you very much for the opportunity to speak. I'll try to keep this brief. I've listened to the previous meeting, and I believe you would have to check the tape. I believe it was stated by one of the applicants in the last meeting that a 3-2 would fit, but you would have to check the tape. I think that's a question. My feedback is based on the belief that a variance would not be required for a 3-2 home. And if that were the case, that would be in keeping with the neighborhood. So I looked at, there was a graphic that showed like the GIS of the area. And I looked at over 25 properties around this one, and I found only one that was more than 3 bedrooms. So I appreciate that they have done a lot of work to get their design to fit. But I think that, in my opinion, what they are asking for is unusual for the neighborhood. Regarding ADUs, I'm not aware of any. There may be this, again, this is black and white factual information that we could find out. I think that's unusual for the neighborhood. And I think larger than 3-bedroom homes are unusual for the neighborhood. And so it's for that reason that, my opinion is I like the nature of the neighborhood. And I think this is that following the rules that we have followed allows this property to be developed in a completely appropriate manner for the neighborhood.
Thank you. Just for the board's context, you're in the neighborhood or you're nearby or you're?
I
somewhere in
am
the neighborhood?
3 doors down.
Okay, that's
Yes,
great.
I'm on Patriots Drive, 3 doors down.
Great. Thanks so much. Appreciate
Yes.
you. And anyone else here to speak? Welcome, ma'am. We'll swear you in first.
Please raise your right hand and state your name.
Molly Zalewski.
Do you swear or affirm to tell the truth and nothing but the truth?
Yes.
Thank you.
First, thank you to all the board for your time and expertise. I live on 213 Patriots Drive, which is 3 doors down from Margaret Lane. Having attended last month's hearing and reading the revised variance dated 12/27/24, I feel compelled to share my unease regarding this variance request. The revised variance description does acknowledge that the purpose of a setback is to ensure adequate spacing for safety, privacy, and functionality. It goes on to say this variance does not compromise the community welfare and has no impact on others. As a community member, I would challenge this assertion. As the applicants characterize their compliance with the building code as an unnecessary hardship, I would like to highlight the hardship on my neighbors and myself by noncompliance. My comment will address 3 areas: the lack of clarity for the need of the variance, the self-created hardship, and the claim that this setback will not compromise public health or safety. 1, regarding the lack of clarity for the need of this variance. The filings and words under the oath are inconsistent. The application dated September 10th, 2024 stated that, quote, "The required setback in combination with the right-of-way on Margaret Lane does not give enough room on the property for any type of septic system." However, during the December 11th meeting, we heard under oath that a 3-bedroom, 2-bath home with an appropriate septic tank was possible without a variance, and I did double check that. Also incorrect that was mentioned today was that the top of Margaret Lane only has 1 home. There are 3 other people who use that road. It is very steep, and there's also undeveloped land at the top. So there may be more traffic in the future. 2 statements from the applicants at the end of the previous hearing are worth repeating as we argue hardships, including that not allowing an ADU is a hardship. Quotes, "It's not about the ADU, it's about any building the size we are wanting. Any 4.3 is going to require a septic system that will not fit on this property." And another one, quote, "We are eventually planning to have a family. It's just not going to be an adequate space," end quote. This statement suggests that maybe an ADU will not be built as the kids would obviously not be in a separate structure. The revised variance also states that granting the variance ensures that we can make reasonable use of our land in a manner consistent with Buncombe County zoning and neighboring properties, end quote. Our neighborhood is predominantly made up of a 3-bedroom, 2-bath house, exactly what the law can handle without the variance, according to the last meeting. Just like the Hendricksons, I too moved to the spacious Riceville Forest neighborhood from the more cramped West Asheville. The setbacks in place at Riceville Forest are a huge reason I moved here. Hardship. Number 2, the variance description claims the hardships are due to the unique physical characteristics of the land, end quote. The property of 5 Margaret Lane, like most of the neighborhood, is a steep property with odd-shaped lot lines requiring a well and septic. This challenging terrain is clearly evident and not unique or peculiar to this neighborhood. This being the case, it doesn't seem fair to allow one party to be relieved of the roles we've all followed through a variance. To discover it is incompatible for the desired use from feasibility studies performed after purchase is a hardship created by the buyer and should not be excused from the ordinance, claiming an unfair burden, especially considering that the design is exceptional by neighborhood standards. They took a risk when buying this property and now are claiming a hardship. Safety. The revised variance explicitly acknowledges that setbacks ensure spacing for safety. Then it goes on to say that, quote, "Reducing the setback on one side of the property still aligns with these goals, as it accommodates a necessary septic system without compromising public health or safety," end quote. This is a bold and self-serving statement. There is no backing evidence from someone with training or experience in these matters. I've spent many years in emergency medicine, and the medical field states safety standards that are confusing to the general population. My favorite of those is nothing to eat or drink after midnight before surgery. Many of my patients come in day of surgery and confess to just putting a little bit of cream in their coffee. No, it really wasn't that much. Enough, though, to increase stomach acid, which can be aspirated into the lungs with lethal results. A simple rule with profound ramifications. All this to say is there is a lot we don't know that the regulations account for. and safety should never be taken lightly. Margaret Lane is not even 10 feet wide and very steep. Do we know that large emergency vehicles will be able to safely get to all those above 5 Margaret Lane, and it's more than just one person? I find it hard to believe that one can make that claim without any proof that the setback is unnecessary for safety. In summary, I'm concerned that granting this variance will set the wrong precedent for my neighborhood. What is the point of having ordinances if there is a limitless view on the definition of a hardship? At the end of the day, the Hendricksons can have a really nice home. We all saw it. It's a beautiful 3-bedroom, 2-bath, and truly a 2,500 square foot home. They put my house up there as 3,300 square feet, and that would include the basement. So 1,300 on top and 1,300 on bottom, if you read the little print. And I would like to continue living in a neighborhood that prioritizes aesthetic appeal and community welfare. I hope the board will consider the fairness for the community, families, and neighbors of Riceville Forest. I'm here today asking the board to uphold the integrity and character of the neighborhood I love now and in the future. Thank you.
Thanks so much. Not yet, sorry. Anybody else here to speak on this matter? Thank you, sir. Please approach. Thank you, sir. We'll begin by swearing you in.
All right. Please raise your right hand and state your name.
James Campbell.
Do you swear or affirm to tell the truth and nothing but the truth?
I do.
Welcome, sir.
Yeah, good afternoon, and I appreciate the board letting me have a little bit of time here to go ahead and address my concerns in addition to my neighbor's concerns. The first thing I'd like to address is the variance dated September 20th, 2024. This is indicate how the hardship did not result from actions taken by the applicant. So we were not aware that we need to consider both the setback and the right-of-way requirements when purchasing the property. That's kind of strange because they had all those people looking at the lot before they bought it. They had the engineers, they had the county board, a whole bunch of people that they said in here. So I was a little confused on that one. And then a couple of things I've been reading this, which is good reading if you're trying to get sleep at night. But there's a couple of things in here that I wanted to address. On page 14, the inference says, what you need to have a variance. And this sort of infers that the ADU constitutes a unnecessary hardship, which I don't know if that's really is a hardship. And then also says the topography can't be any different than the rest of the neighborhood. And the topography there is straight up and straight down. And that hadn't changed from the time they looked at the property to the storm to now. So that hasn't changed. Is our understanding that the ADU is going to be used for an Airbnb or something like that. The R1 district is intended to protect single-family communities from encroachment of non-conforming uses. Building an ADU to be used as a vacation rental is a non-conforming use. Page 22 shows a nice little.
That's not a correct statement, sir.
Or maybe it's from the
That
ordinance.
is not a correct statement.
But maybe it's from the ordinance, but it doesn't apply to this situation.
Okay, all right, then, thank you for clearing me up on.
I just want to make sure you're supposed to be giving facts.
Yeah, well, thank you so much for that. I'm a doctor, not a lawyer. Let's see. And on page 44, I may be incorrect with this one. It says ADU cannot be used for business. Is that correct?
An accessory use structure would be allowed on the property.
To be used for business.
If it was a home occupation, yes, if it meets the thing. But yeah, no, they couldn't be running like a landscaping or a coffee shop. But yes, if it was like an accounting office or something like that, or maybe doing therapy in the unit.
All right,
Yes.
thank you for the clarity on that point. And again, I'll echo Molly's statement that granting the variance is going to be, could create a legal precedent and change the character of the neighborhood. Thank you.
Thank you, sir. Anyone else here speak as a witness on this matter? Going once, going twice, going thrice. Any closing statement from the applicants? And during this, you may decide to address anything that's already been mentioned during public comment. You feel free to both give a closing if you want to. Yeah.
I just want to.
I do think it's worth pointing out the last witness realtor contacted us trying to sell a parcel of his land of half an acre to us so we could do the project. So I think maybe there's some financial incentive for the variance to not be passed. So that's.
If you have anything else?
Yes, we would like to request a continuance to have the opportunity again to have Stuart come in and talk with you guys and give us a chance to speak with him. So,
And we're
thank you.
okay after you close the public hearing with a 1-month extension for that.
Yes, please. Thank you.
I think we're all set. We can close the public hearing at this point. Joel, please.
Yeah, I got can I ask the applicant a question or no?
We just closed the public hearing, but we can reopen it for that purpose if you'd like to.
Yeah, I'd like
Okay, let's reopen it for that purpose.
Yeah, with this property, I've had some experience with this. Where's the well going to be?
It's, if you look at the improvement permit, it's on the very southern western corner.
Okay.
So
It's supposed to be down there. I see it. It's on this little printout. Any other board questions at all for the applicant? Thank you very much. We'll close the public hearing and open for board deliberations and a motion.
Yeah, I would recommend and grant them a continuance. 2 reasons, get some experts in here, okay? Again, about the emails. And the other thing, one of the witnesses brought up the health and safety issue. I'd rather have an expert come in and testify about that. The other thing too is it's been brought up, looking at what could be a 3-2 option, which they have not addressed. So that's why I recommend a continuance, because if it doesn't pass, I believe there's a certain time limit before they can come back before the board.
I would second Joel's 3-2 recommendation, and because I think it's a year. If they get denied, then it'll be a year before they could come back again. And so one of the things I would recommend if they want to continue, or we've heard that they want to continue, is to look at another option so that they would let the ADU go and do a 3-2 and fit more with what the size of the lot and the rules are. And they wouldn't even have to come in front of us if they followed the rules and designed to fit the rules of, so it can apply to be fair to all in Buncombe County.
One question that I have for regarding the request for the continuance, and this is addressed to the people who would seemingly, all other things being equal, would vote against the request. Would those people say confidently that there might be some testimony that would be given by another person that would cause them to want to grant the request for the variance? Is it possible? Because if it's not possible, I wouldn't want to waste everybody's time.
That's a good question, and I'm happy to chime in whenever we hear from more board members on that one. Yes.
Yeah, for me, the only way I can make that decision is hear from the experts rather than just read emails, okay? And then one of the things, I think I mentioned this last time, the applicant mentioned what hardships you go through without, requesting that variance. And again, a situation like this, being here twice requesting continuance, I recommend you get legal counsel. to
Yeah, I would
present-
agree.
Yeah, to
That's the
present your
applicant's-
case.
that's
I'm
the
not a
applicant's.
lawyer, okay? Maybe one of you is a lawyer, I don't know. But I would really recommend, because you brought up as precedent previous cases. You know, that's why I say you may want to get yourself a lawyer. And again, I'm in favor of a continuance. There's-
Always, thank you, Joel, very much.
Yeah.
I'm always open to any request to continue or to hear more evidence. But the questions that I think the board members and I posed last month and this month are the same and didn't result in any new changes in the plan or options for different plans from the applicant, and still aren't addressed. And so I don't think that anything I hear from staff is going to change that, but I'm open to hearing something that would. But again, I think the answer to the question the burning question I have is, does a 3-2 with an unfinished basement, this lot fit without a variance? And the answer to that, I believe, is yes.
I just want to make sure, is it
That I'm a no
the,
on this.
is it the size? Because once again, we're getting into
Yeah.
like design details. Is it the size of the structure? I mean, if they had a 4.3 and it was still 1,700 square feet, you know, because it seems like to me there is a correlation between the size of the structure and how big the septic system needs to be.
There's a correlation between those, sure, but the size of the septic system is 4-bedroom right now, and they want to build the house and the ADU.
No, I just want to make sure that we're clear as to, is it the square footage or the number of bedrooms that would affect the size of the septic field?
The bedroom.
The bedroom.
Okay, I just want to make sure that you all are aware of that.
Drive the decision.
So Kurt, I think what I'm hearing is they're trying to fit 5 bedrooms into a 4-bedroom septic. And that's what,
A 4-bedroom system, but the ADU does not count in that calculation.
Right. I'm just trying to make sure that we
Future
have,
Basement build out would count in the calculation.
that if like they modified the design and that, you know, they built it up or they built, you know,
Yeah, the testimony is that doesn't change the size of the septic system.
okay.
So and that's from staff.
and the testimony is that there is no changing. This is what we want. And the only option that we want.
I get that.
And that if and is a 3-2 an option has been the
I
question. from the
get that,
board.
but I just want to make sure that it's fitting the residents, because right, they're allowed to have a single family residence on the property. And in order to have a single family residence, they're also going to need to be able to have a septic system.
And they can do that.
So that's what I'm trying to make sure is what the minimum and what,
And the board's being asked again this meeting for a second time. Can they fit a 4-3 septic and a
And an
4-3
ADU.
house with or without an ADU on the property?
okay.
And without a setback. And
That's
without a variance.
what
And
I
that's the
wanted to
hardship
make sure that
hardship
clarification.
We're being asked to define there and verify, and I cannot get there. I'm not gonna be able to get there with staff testimony either. But if board members really do want to hear that from staff directly, I'm open to continuing to do that.
Okay.
It's their best shot.
Right.
Yes.
If staff were able to say we could fit a 4-3 and a house and an ADU, yeah, that'll make them happy. But if not, they could fit if they can't fit a 4-3 in a 4-3 house without an ADU, that's still not what they're asking for. So that's why we can't come to a solution. I don't think that helps the applicant.
But it's not going to be useful if we have the same conversation the 3rd month in a row.
That's right. That's the
So that's the pitfall.
yeah. We're weighing that right now. Do we still feel the same over here about continuing?
Yes,
Go ahead. Okay. So is there a motion to that effect?
I move that we continue.
Hearing a motion that we continue this case to a date certain, that's the February regular meeting.
Second.
And there's a second to that motion. All those in favor, please say aye.
Aye.
Any opposed, nay? That motion passes. Thank you all so much. Moving to now.
Can we do a bio break real quick?
Yeah, we're going to do a quick 5-minute break, a short one this time, 5-7 minutes. Thank you. seats and come back to order at this time. We'll find our seats and come back to order at this time. Oh, mic working? Is my mic working or not? Maybe not. I know, really. Is it working? Hello? You can. Okay. Great. We're back to order. Thank you very much. We'll move to case ZPH 2024-00036 SCM Concrete Plant Special Use Permit. We have Savannah Glantz here to introduce the project.
All right, let's try that again. It's not doing this. See? Catch because it's in another window. Is that what you need right now? Thank you to everyone's patience as we face even more technical difficulties. Oh, thank you. That was quick. Perfect. All right. So again, my name is Savannah Glantz. This is to see a CM concrete plant. I certify that this public hearing was properly noticed and all applicable parties were notified of the meeting in accordance with the general statutes and county code. And I ask that all applicant and staff materials be accepted into the record as evidence.
Hearing no objection, those accepted.
Thank you. So again, this is a review of ZPH 2024-00036 SCM concrete plant. Applicant is Stedman Smith with Southern Concrete Materials. The property is located at 450 and 460 Goldview Road, and the combined total acreage is 99.13 acres. It'll be serviced by septic and well. The property is zoned open use, and the special use permit proposes a concrete plant with associated buildings and material storage in an existing quarry. The property is accessed via private road off of Goldview Road. The surrounding zoning districts consist of open use to the north, northeast, and west, and EMP R1, R3 to the southeast. The French Broad River comprises the majority of the western property line. The surrounding properties are mostly comprised of vacant land, single-family properties, and properties to support the quarry operations. If the board approves this, staff recommends the following conditions of approval. Project must be constructed as depicted in the site plan. A soils investigation report, septic test, or other documentation showing the site can support the proposed development must be submitted prior to master SPR approval. An air quality permit is required prior to the construction and operation of the concrete batch plant. The applicant must submit for closeout of stormwater permit STW 2019-00008 prior to the site plan permit approval. Projects must be constructed as depicted in the site plan, and applicant must agree in writing to these conditions prior to the commencement of site work.
Thank you. Any board questions for staff? And we'll have the applicant at this time. We'll ask about that. Any standing applications for this matter?
Yes, we have
Yeah, one
received
here. Okay.
3.
We have 3 on file. So we'll start with you, ma'am, if you like. There, that microphone's on, absolutely.
Yeah, that'll work.
And we'll start by swearing you in.
All right, please raise your right hand and state your name.
Christina Sobin.
And do you swear or affirm to tell the truth and nothing but the truth?
I do.
Thank you.
Welcome.
Thank you. Thank you for giving us time to speak with you all. We really appreciate it. I'll just say at the start of this, we've had very little time to get together are thinking about this project. The first notification we received of this was the week before Christmas. Many people were already out of town or occupied with the holidays. And then we didn't get the postcard about this hearing until almost Christmas Day. One meeting that SCM held with us for the community, which we appreciated very much, was on January the 2nd, the day after New Year's. We had many community members show up, fortunately, but there were still many people out of town. So we've been scrambling to get organized so we could understand what this situation poses for our homes and our health. So my name is Christina Sobin, and I live at 40 Spanish Oaks, directly off of Goldview, within 1,000 feet of the proposed concrete plant. My home is in an R1 zoned residential neighborhood. In fact, the R1 zoning of my home was one of the main factors in my decision to purchase my home. I read the Buncombe County zoning ordinances before completing the purchase of my home and trusted the stated purpose of the Buncombe County zoning to ensure orderly, attractive, and economically sound development, and very importantly, to protect existing property values in Buncombe County. Now, as a member of this
Mr. Chair?
R1,
Excuse me, just a minute. Can I interrupt? Just to clarify, what we're going through now is a vote on whether or not to accept her, not to listen to.
Standing application.
It's a standing
So I'm
application, not to listen to what your argument
I'm
is.
listening to make sure that she's going there, and if she's not going there, I'll make sure we.
Thank you. I appreciate that.
Yeah, thank you very much. Sorry for the interruption. Yes.
I'm here on behalf of the applicant.
Yes.
And I'm hopefully will demonstrate professional attitude and decorum by not objecting to the witnesses. At the end of their presentation, what they might say, I might make some points similar to what Paul brought up in terms of relevancy. But just so that the record is clear, I'm not going to keep objecting.
Sure.
Even though you described it as like a courtroom, it's a little bit more.
It's a little more
informal, as you know. So I'm going to.
Thank you. Thank you for
let her
that.
speak, and then we'll deal with it.
Thank you for that.
And Mr. Justice, you will have the ability to cross-examine or examine any witness if you choose.
And that's fine. And
So sorry for the interruption, ma'am, but
No,
as long as
that's
we're already
fine.
here, the interruption point, just make sure you're driving at the reasons why the board should accept that standing
Yes.
application to participate as a member of the exchange here, and not as a
Okay.
witness, yeah?
all right, I'm sorry for the long introduction.
No, you're fine.
I'll move on. I'm going to address how 3 issues related to the concrete plant proposal will adversely affect my health, well-being, personal safety, and property value. These include the adverse health impacts of living in close proximity to the daily use of carcinogenic fly ash, the detrimental and injurious effects of draining our water table, and the danger to pedestrian safety and convenience and uncontrolled truck traffic flow on our 2-lane, 35-mile-per-hour neighborhood roads. To ensure my comments are relevant, I've aligned these 3 issues with items 1, 2, and 4 on the special use application that SCM Concrete completed. The first item on their application, I believe, is indicate how the proposed SUP will not adversely affect the health or safety of persons residing or working in the neighborhood of the proposed SUP. I live within 1,000 feet of the proposed concrete plant. The proposed SUP will adversely affect my personal health and safety. Fly ash or another silica source is used in the production of cement needed to make concrete. It is well established that fly ash is a carcinogen and increases the likelihood of lung, liver, kidney, brain, and other cancers. Fly ash contains heavy metals such as lead, arsenic, mercury, and cadmium, and these have toxic and neurotoxic effects in the human body. And I'll just mention that I am a PhD environmental researcher. I have researched the effects of the neurotoxic and the toxic effects of lead exposure in children. I have over 50 publications, and I'd be happy to make my CV available to any of you. Fly ash also contains substantial quantities of silica, which damages human lung tissue when inhaled. The way in which fly ash in any silica source is produced, excuse me, it's very dry in here, produced, transported, transferred, stored, managed during use, and disposed of critically impacts human health. Living within 1,000 feet of the production and or transport, storage, daily use, and disposal of fly ash and other silica sources is a direct threat to my health, my well-being, and my quality of life. Depending on how fly ash is manufactured, transported, stored, used, disposed of, fly ash can become easily airborne. This is one of the greatest dangers of fly ash. It can settle in soil, home gardens, and can enter home air supplies. If fly ash is dumped into unlined storage ponds or into landfills, it can leach into the soil, percolate through to the groundwater, and contaminate the water table. The proposed SUP will adversely affect my personal health and safety by allowing the transport of carcinogenic materials through my neighborhood and/or by allowing the manufacturing, storing, transporting, and disposing of carcinogenic materials at the site of the concrete plant, which is 1,000 feet from my home, and by contaminating the air, soil, and water with known carcinogens. So my second point, and my second point is tied to the second item on the SUP application. Indicate how the proposed SUP will not be detrimental to the public welfare or injurious to property. The proposed SUP will be detrimental to the public welfare and injurious to the property of residents in our R1 zoned neighborhood and will be detrimental to my personal welfare and injurious to my private property, my home, and all the homes on the streets adjacent to the site of the proposed project on Goldview, Patty Lane, Spanish Oaks, Rice Meadows, Rufus Ridge, Aiken View Drive, and Aiken Road are on private wells. This includes a total of 78 homes. Massive amounts of water are required for the production of cement and concrete, and the water supply for the proposed SUP will be drawn from the water table that supplies my well and 77 other residential wells. Estimates of daily water use at concrete plants range from 4,000 to 5,500 gallons of water per day. That's well over 1 million gallons of water taken from our shared water table every year.
Sorry to interrupt again.
Yeah.
Can we take a more of an aerial view and sort of look at the third point at which you're contesting as well? The details of those we can go into later on.
The details of
The effects of fly ash and the effects of
I see.
those criteria and what concrete
Okay.
plants typically do.
So-
All of that's secondary. Your three areas of damage would be the special damages would be that.
Okay,
area you
would
wanna
be
hear
the
about.
drawing of the water.
Mm,
Yeah,
yeah,
the
just-
excessive, the massive use of water and our concerns that our wells will run
Ma'am,
dry.
ma'am,
Yes.
just for the standing application, it is not about, it is about you and how you are going to be damaged and how your damage is different from the rest of the community. That is what they are focusing
We're not
on
proving
right
anything
now.
As far as the detail, we're just saying you're just alleging special damages.
Right,
As
but
far as-
but you need to focus on how it affects you and your property as opposed to the community at large.
Okay, so I'm very concerned about my fill rates in my well. I'm very concerned about my well running dry. I'm very concerned about the long-term effects of this massive water draw on my well if I would want to sell my house in 5 years, in 10 years. Okay, and especially, I want to say also that I'm especially concerned with climate changes the way that they are. Our drought conditions are becoming more and more frequent. And as we all know, maybe we don't all know this, the water table naturally fluctuates over time with different seasons. It tends to be higher in the winter and the spring, lower during summer and fall. Given the nature of the industry and the needs for production, I doubt very much that there would be any proposal to stop production when the water table gets too low to sustain the amount of water needed for the concrete. So that makes my well and my property value and my health even more at risk. And then the third point that I want to tie my comments to is item number 4 that they would have been answering, indicate satisfactory ingress and egress to the property proposed thereon with particular reference to automotive and pedestrian safety and convenience and how traffic flow and control have been provided for. The ingress and egress to the plant is not satisfactory. In order to get to the major highway, we have been told that all of the concrete truck traffic will travel through our R1 zoned residential neighborhood, 35 mile per hour, 2-lane road on Goldview, Aiken Road, and New Stock Road. Our 2-lane road has no sidewalks. Many of us walk, run, and cycle on our neighborhood roads, as we should be able to do, and cars are respectful of our presence. Currently, however, trucks going to and from the quarry operate recklessly, irresponsibly. Every day, the trucks ignore the 35-mile-per-hour speed limit on our roads, engage jake brakes, drive down the middle of the road, create special danger around multiple blind corners and sharp downhill curves. Our streets are rutted, cracked, and damaged from the weight of the current trucks. The concrete trucks will be added to the current high-volume reckless truck traffic from the quarry and asphalt plant that passes daily and on weekends through our neighborhood.
Is one of these roads in front of your property?
I'm sorry?
Is one of these roads in front of your property?
No, it is not.
That'll be using.
I'm off of Goldview.
Okay.
Okay. So I'd like to share with you one more thing. I've made up some tables. These are data that are available.
I think at this time we might hold off on that because it's too detailed for what we're doing right now. But what, is that right? I've heard though.
Once again, does this information somehow relate to your special damages? Or is this something that is more of a community,
That's a good question.
a public safety type issue?
Can
If
I tell you what the table is and maybe?
Yeah, please.
Yeah, I would also want you to share a copy or at least provide a copy to the Mr. Justice sitting next
I'd
to
be happy to. I have at least.
Well, at least make sure that Mr. Justice gets to see what you want. Thank you.
Can I tell you?
I realize that you'll be allowed to present all of this stuff at some point in the meeting. It's just a question
Of when?
of
Yeah,
now.
yeah, it's
or later.
really whether it relates to your standing application, not
trying
the
to make sure
whole.
that-
We're just trying to see if you have unique damages. If so, are you eligible
Okay.
for standing?
Okay, I think I've probably said what my unique damages would be.
Okay.
So
So-
I'll hold off on this.
Just to summarize, we've got four areas of concern here. The fly ash contamination being one broad area.
Yeah.
Property damage to your property related to water table, well, ingress and egress, et cetera.
Exactly.
Property value impacts in the future. And access to neighborhood roads, including roads that you use
Yes.
in your, okay. So are you planning to, if you're approved as a party withstanding in the case, are you planning to introduce qualified evidence or expert testimony related to those areas from professionals in the industry or your own observations or other qualified
It would
information?
have to be my own observation. We've had very little time to get this together. And so the main point, I think, of this is to ask for a continuance of 2 months. So we have time to gather the necessary experts, do our own water table studies, and also get experts on fly ash. That is not an area that I've personally researched, although I can interpret the neurotoxicologic literature.
Wonderful. Okay. We appreciate your certifications and you clarifying your
Okay.
experience there too.
Okay.
Board questions?
Yes.
How long have you been in your home, in your own Spanish Oaks?
I bought my home September 2022.
Okay, so 3 years. And so I know you're not a surveyor, and neither am I, but I'm guessing if you're within 1,000 feet of proposed, that several of your neighbors,
I'm within 1,000 feet.
right,
Yes.
but I'm guessing several of your neighbors
yes.
are also, so you're not in a completely unique situation. A lot of your neighbors are in this, they share this
We're
situation with
All
you.
on private wells. Yes.
Okay.
Yes.
And I'm an old Weaverville boy. I'm just asking, when you bought your home, you were aware that there was a massive open mining operation within 1,000 feet.
Yes, I did. I went down to the quarry. And in fact, before I bought my house, I went down to the bottom of of this potential property every morning to hear the noise, to see what the truck traffic was. I went, down Goldview to Ledges to see what the traffic would be. And during that period of time, when I investigated the properties, I did not see anything like the noise that I've experienced since I've gotten there, or the truck traffic that's there now, or this new site that's now being proposed with these dangers.
And when you bought, were you aware there was a asphalt plant there that produces and burns
Yes, I was.
liquid asphalt,
Yes.
creating fumes?
Well, no, I was not aware of the fumes. The fumes did not become apparent until February when I was in the house. And then I made complaints. I have documented complaints that I made, and it turned out that was just around the time they were changing out all their equipment, so they were updating everything. But I have a record of calls to the Department of Air Quality, and we had many conversations with Hedrick, both about the noise and the fumes is another issue. I went and talked to the people at the asphalt plant as well.
And when you bought your home, were you aware you were within 1,000 feet of Austin Powder Company that stores tons of explosives and dynamite and blasting caps and
Right.
accessories for explosives?
I was told that Austin Powder was leaving when I was buying my house. So I was aware of them, but I knew that they were leaving, if they hadn't already gone by the time I bought the house.
All right. Okay, that's it. Thank you.
Okay, thank you.
Other board questions?
Yeah. Can you just reiterate how you are special than any of your other neighbors?
Yes, I own my own well. None of my other neighbors use my well.
Okay, but they all use the water table.
The effects of the
This-
property and what it will have on your property.
Yeah,
only,
what's
not-
different
not your
than you,
neighbors.
than any of your other neighbors? Like the water table, everybody's got the water table.
Yes, but only my well. I mean, it is only my responsibility to take care of my well. My neighbors don't have responsibility.
So have
for
you
my
put
Everyone
any
else is
dollar-
on city water?
I'm sorry?
Everyone else is on city water?
No one's on
Okay, so
city
everybody has a
water.
private well?
Everyone's
Okay,
on a
so
well.
Something that's not related to, so that everybody doesn't have in common.
So
Shouldn't your
everybody has
property.
their own well in
Their own
common with
private
you.
well.
And do you, have you quantified any monetary damage that it would be, that would be special to you with your own well?
Have I quantified? I'm not sure. Could you, what do you
Like,
mean?
do you have dollar figures that how you would have to pay different numbers, or it would impact you negatively, different numbers than your neighbor?
Oh, we haven't had a chance to go there yet. We've had very little time to pull this together. That would be something certainly that we would all investigate in the coming 2 months if we're able to get the continuance.
I don't know that, I don't know if she understands what we're trying to.
Yeah.
Can, Kurt, do you want to go through real quick, what she has to prove in this particular hearing?
Yes, I was actually in the process of pulling that up. It might be before I do that, you may want to give Mr.
Yeah, let's go ahead and do
Justice a chance to ask any questions, and then I will answer your questions when I get my thing pulled up. I'm sorry.
Thank you, Ms. Justice.
Yes, thank you, Mr. Chairman, members of the board. I want to say two things up front.
Please use the mic. Thank you.
I want to say two things.
I don't think your mic's on yet.
It's been turned on a couple times, but.
Here, too. You're professional right there.
There you go.
Joel, can you hear him? He can't hear you.
That might not be a bad thing. Check. Can you hear me, Joel?
Yeah.
All right. Sounds good. All right. Couple things. The three good things about this particular project is there's no setback variance, there's no ADU, and I will not have a PowerPoint presentation. The second thing I want to make about standing, and I've said this before, I've been before this board a number of times, and my clients always want to be fully transparent. And so there is a legal threshold for someone to have to meet. That's their burden, just to get a party status. It's all legalese. Regardless of whether they get party status, we are available for all questions. We're not going to sit here and say people can't speak. So I will want to say to you that if you have information you want to share, albeit I may ultimately object to some of it, I want the board to understand that we will still afford a lot of the same rights as if they had standing. But to go back to the point of standing, it is a legal requirement and a burden that they must meet. And I can talk about the test, but I do have some questions of Mrs. Sobin. Ms. Sobin. My apologies. All right. First off, just to get where your property is in relation to the project site, I have an aerial that I want to show to you. And if I may, just hand it up so we can get some relationship of where Ms. Sobin's property is to the site.
Mr. Justice, do you have an additional copy of that for the record?
Thank you.
All right, so just to let the record reflect, I marked that as Exhibit A. This is sort of a site map that deal with the standing applications. So Ms. Sobin, you see this is an aerial of the general vicinity of the quarry, right? You can see that?
Yes.
All right. And I have marked on here where the proposed site is for the concrete plant. You understand that generally what we're talking about? And based on my research and looking at your deed and the county tax records, it appears that you would be number 2 on this map.
Yes, that looks right.
Okay.
No, I'm right. Well, let's see. Yes, that's correct.
All right. So when you say you're 1,000 feet approximately using this map, this does accurately depict where you are in relation to the proposed site, right? In terms of your number 2.
Yes.
Now, from what I can tell from here, and the colors matter, the colors show different zoning. As you can see, yellow here is R1, and that's where you said you bought into.
That's right.
But it looks like immediately adjoining your property is EMP. You see that?
That's a buffer.
Well, do you know what uses are allowed in EMP? Did you investigate that before you bought your property?
No, I didn't.
All right.
But I understood it was electric company. I did call the electric company and I learned that the electric company uses that for their power line.
Ma'am, could you please speak into your microphone?
So
No
an
worries, thank you.
So an EMP district is an employment district. It's actually one of the least restrictive zoning districts in the county. You didn't know that?
Yes. Well, wait a minute. I discussed this. So I bought my property from my neighbor who's been in that area for 20 years, I believe, David Miles. And we talked about that piece of land there. And I understood that I learned, and I don't remember if I learned this from research online or talking to other people, that Hedrick had wanted to buy that property to expand their quarry site, and that Duke Energy would not allow them to do that. And the Duke Energy, and I did talk to someone at Duke Energy who told me that that site would continue to be power line site. So that was my best understanding of what that land would be used for.
And I'm talking about zoning. The way the county regulates it, it has an EMP zoning district.
Mhm.
Did you investigate the allowable uses in EMP?
No, I took, the word of people I was talking to.
Okay. And then next to EMP are sort of the non-colored, more of the bland looking thing. That is all open use.
Yes.
And the vast majority on this map, or a good percentage of this area, is zoned open use.
I know that.
Did you do before you bought your property, did you do any research of the allowable uses in open use?
Yes, I did.
Okay. Do you know that that is the least restrictive zoning district in the entire county?
Yes, I did when I bought my land.
Okay.
And I did, and I do now.
All right.
But
Now,
that doesn't negate at all that I'm in an R1 zoned residential neighborhood.
well, ma'am, our property is in open use and you're
Yes.
seeking to negate what we can do. So at the end of the
Oh.
day, the property site is open use that you're
This
challenging.
I understand. However, it's my understanding as well that the use of open use cannot adversely impact an R1 neighborhood, which happens to be right next door. And that's the complication, is having an R1 neighborhood exactly behind an open use property.
Well, we'll get into adversity here a little bit, maybe later. But it looks like when you bought the property, I'm looking at a copy of your deed. It looks like you paid for your property about $789,000.
Yes, that's right.
Okay. $789,000. That was back in 2022.
That's correct.
Do you believe what you paid into the property, do you believe that that has gone down in value?
Right now, no. And I
Okay.
want to protect my property value and make sure it doesn't.
Okay. Now, to hit upon some of the points that some of the board members made, your 3 areas that you have expressed issues with, fly ash, you would agree that that issue you have is one that is shared by the community at large.
It's not clear to me. This is what we need time to get expert opinions on. because certainly prevailing wind directions can make a huge difference in how airborne pollutants reach different homes. It could very well be the fact, and I know, and I've talked with Jason and Ralph and also Joe a little bit about this, we get certain negative impacts in our cul-de-sac that no one else gets because of the lay of the land. And so we need experts to probably come here and explain to all of you and so we can, and we need to understand which specific houses might have special impacts. So I'm not willing to say that, yes, absolutely, all the impacts that affect me will affect everyone else. That could also apply to the well situation. We don't really know. We need expert advice on that, which is why we're asking for a continuance.
But the reality, though, Ms. Sobin, is you cannot, under oath, tell this board that you're in fact unique and special, that these impacts will only uniquely apply to you. You don't know to be able to discount that what you are complaining about wouldn't affect a much broader community at large.
Right. We haven't had the time to get the expert opinions, the expert advice to guide us in a statement like that.
And when you've made statements about fly ash, for example, do you understand how a concrete plant operates?
I've done my best to educate myself in the 3 weeks I've had to prepare for this. And I do have a rough idea, but I was just talking to Joe about how we need to go down there and see the plant and see the quarry and understand more about all of this.
So the totality of your knowledge is you've spent the last 3 weeks, I'm assuming, Googling things?
And talking to experts. My nephew, 2 of my nephews actually work in the concrete industry, and one is a PhD civil engineer. We have consulted with them. I mean, they're my family members, but they're also very well trained and have been doing the work for over 20 years.
In terms of the other 2 areas you had complained about, in terms of the water table.
Yeah.
Again, you can't say that is that you don't know if that is unique to you or a community at large issue.
We haven't had a chance yet to do those water studies that we very much want to do to figure out who would be most vulnerable.
Do you know, you said between 4,500 gallons and 5,000 gallons.
4,500 and
Yeah.
5,500 is the estimate that's as widely accepted, I believe.
Okay, and that deals with well capacity, right? In terms of what the maximum could be drawn down, right, a day?
Yes, that refers to the average daily use at a typical concrete plant.
Well, a typical concrete plant, this current concrete plant, you understand, has 2 storage tanks that are proposed that will fill up with water and will in fact be the primary source of drawing water rather than wells. Did you know that?
No, we asked about water at the meeting on January the 2nd, and many of our questions weren't answered. Much of that meeting was taken up with discussion of traffic.
Well, with all due respect, when you said that your questions were answered, were you giving answers? Or were you told, well, I'm not going to answer that, or I can't answer that? Was there a difference?
I'm not sure what your question is, so I'm sorry.
You said your answers, you weren't given answers. You asked questions and you were provided answers, right?
No.
So you had a community meeting where you asked questions and my client stonewalled you?
We tried to ask a question about the water, and we were told that there would be water studies done. There was also a map shown at the beginning, and there was some mention of water. One of our residents said, well, my well runs dry now, and I'm very afraid. And there was no response to that. She kind of opened that door. And I think, and like I said, the thing that has been most frightening to the neighborhood regarding the quarry is about the dangers the traffic poses on the streets every day. That's most salient in people's minds. And so the discussion at that meeting kept going back to the traffic.
The water study was something that the neighbors asked my client to do, not that my client was in the works of doing a water study. Correct?
I don't know.
Okay.
Is that correct?
Well, that's what I understand to be the case, but if you don't know, that's fine.
Yeah.
Okay.
And I think if it would be very helpful if more information could be made available to us about fly ash, about the water situation, and exactly how all of this was going to go. We don't have that information. That's all I'm saying.
You are here today and you will be given all of that information upon a
Wonderful.
question.
Wonderful.
In terms of the water production again, do you know how much water a typical home draws down from a well?
Yes, it's estimated to be, the estimates tend to be high. The estimates are oftentimes 80 gallons per day, but the actual real use is closer to like 50 or 55. Of course, it depends completely on the number of family members, the ages of the family members, whether or not there are family members that have special needs requiring more water than usual. It can vary quite a lot.
According to the information we're going to provide to this board, that the amount of water, maximum drawdown potential, again, we're talking about we're going to have storage tanks. So we're not going to be using the wells every day. The maximum drawdown potential is like having 13 homes. Did you know that?
I calculated 20.
Okay, 20 homes.
Mhm.
So,
20 additional homes.
so in your neighborhood, how many, I think you talked about the fact there were 50 some
Could
odd
I
or,
ask you something about the storage wells, the water storage wells?
well.
Or no?
Well, I did say you can ask all kinds of questions.
That's what I
So I
thought.
don't want to be a hypocrite right out of the gate.
You
Now,
want to finish your, you want to
It's
finish
a
your?
very quick question.
you go right ahead.
Thank you. I
Yeah.
appreciate that.
Yeah.
So where is the water coming from to put in the storage containers?
So the well would be utilized to fill up the tank. Yeah,
Right.
sure.
So it's basically the same amount of water, it's just being stored. So
But
you're
it's not
taking
the
it-
same amount of water every day in any event. All right. In terms of the number of homes, you said there were 78 homes in the neighborhood.
78 homes on the streets. Yes, in the neighborhood going Goldview, Aiken, Patty Lane. I'd have to look at my list. Rufus Ridge, et cetera.
Okay.
All up on that top plane.
All right. And all of those folks, those 78 homes, they're drawing well more than certainly what a concrete plant would draw on, even if they didn't have storage tanks, right?
If
You
members
understand?
of the audience could please keep comments to themselves so that we can hear this discussion.
I'm
Oh,
sorry.
no, not you. You're not a member of the audience. So thank you, and I apologize for interrupting.
No worries.
Anyway, I'll withdraw the question. The point of the matter is even your information suggests that the amount of water that is the maximum capacity of the well we're talking about is akin to 20 homes. Yes? Because that's what
Yes.
you just said.
I'd like to say something that I wasn't able to get to because I think you wanted me to go quickly through the points. But one of the concerns that we have is the rapid rate of drawing the water. So when a huge amount of water is drawn suddenly, there's, our refill rates could be affected in our wells. If the water is drawn very slowly, we don't know. We haven't had time to get experts to talk with us about this,
Falls
but
under your property damage assessment.
yes, exactly.
Assertion.
And Hedrick has well, and they use water in the quarry. You know that, right?
Yes, I do.
And has your well ever experienced an issue?
No, not since I've been in the house. It's been great.
Okay. And last, you bring up the road issue. The road issue is a contention that you have of traffic going down Goldview. Is that right?
Goldview to Aiken to New Stock Road.
Okay. And just looking at this chart you were going to hand up, you're talking about how many homes use that particular road?
How many homes, actually on that chart shows that there are 51 homes that face either Goldview, Aiken, or New Stock Road, and that are experiencing this high volume of highly disruptive traffic every day and sometimes on weekends. And also in terms of the operating hours, there haven't been operating hours observed since maybe, well, I don't know, I think we have a couple of other witnesses who will speak to that.
And this is complaints about how Hedrick, which exists and has existed for almost 40 years, how their trucks affect that road, as well as an asphalt plant that's been around for a long time.
Yes.
Okay.
Well,
And-
it's increased, and I think, and we've talked to them about the amount of increase that they've experienced in their company. There's been a substantial growth in the company, and of course, as they take more and more contracts, and as that operation grows, we get more and more trucks.
Okay. You would have to admit that certainly for the road concern, this concern that you have, it would be shared by the community at large, right? Because you talked about 50 some odd houses just
Yeah, unless-
facing the road.
Yes, I agree with you, unless I'm the one that gets hit on the road. Then
That's
it's
all the
special
questions
to
I
me. I'm sorry.
Thank you.
Okay.
Does the board have questions for the, for the applicant? Sandy?
I've got a question.
Please.
Yeah, your aerial view here, you show the site, you show number 2. What's the distance between that?
She says it's 1,000 feet.
I received a letter from SCM saying your property is within 1,000 feet of the proposed site. And that's the first notification that we got. So I was trusting that SCM was telling us accurate information. By their measurement, my home is, according to their letter, within 1,000 feet of the proposed site.
Would the applicant agree that that's the case?
I'm not a factual person. We can ask somebody later. Certainly, it's more than 3 football fields. Yes, more than 3 football fields. There's a lot of property between us
We
and
understand the
that.
site- The site is the disturbed area it's proposed in the maps and not the parcel limits.
So what's outlined in blue is the Hedrick Quarry and Principal. Our site occupies a small portion of the property.
So the distance that was issued in that letter was related to the proposed disturbed site to her property or from her property to the boundary at Goldview Road at Lot 1.
Yeah, we can, Warren here, who's more familiar with the letter, can speak to that. You'll need to be sworn in.
Thanks.
Please raise your right hand and state your name.
Warren Sugg.
Do you swear or affirm to tell the truth and nothing but the truth? Thank you.
So the way we got that list is we went on Buncombe County GIS. We clicked on the 2 parcels that are in question here, and then we did the buffer that's 1,000 feet. We got the query, which gives us the Excel spreadsheet that gives all those, and then I provided that list to SDM.
So from the boundary. Thanks, Warren, so much.
Absolutely.
Other questions from the board for the applicant? And to be clear, the board, if you are granted standing in this matter, we go forward through the hearing, your testimony is that you are planning to bring qualified evidence or expert testimony on the matters that you introduced here, the 3 or 4 matters.
If I have enough time to get that together, I mean, if there's continuance and we have time to.
Yeah, that's the plan. But knowing that,
I
if that's
see.
the plan, if that doesn't happen during the hearing, the board has to consider all the expert testimony on those topics. And so they would only be able to consider one side if there was lay testimony on your side, for instance, as a for example. Is that understood?
I'm sorry, could you say that again?
Yeah,
I
sure.
guess I'm not
So
understanding.
if we
I
move- if we
apologize.
Grant standing as a participant in the matter. If we go forward and there's not expert testimony presented on your side,
Oh.
the board is only allowed to consider for certain topics expert
Expert
testimony.
test.
That's-
I
right.
understand.
So
Totally
understand
understandable. Yes.
Okay.
And I'm prepared to find expert testimony.
All right. To answer your question, in order the state of North Carolina states, at least for quasi judicial zoning decisions, that any person who suffers special damages as a result of the decision would be considered someone that has standing. Once again, special damages gets to be a question, but it is something that is specific to the person as opposed to damages to the community at large. The person needs to present certain evidence to establish that fact. And that's really what you would be going by, is whether there are special damages unique to this individual that would give her standing.
So going down that road, if we have a few properties that are closer into the proposed site that might experience different impacts than the rest of the neighborhood beyond that, behind them,
Well,
that would be
yeah, right. But I
qualified
think that you need to take each case individually, because it's not like that this is a group effort. So each person would essentially be their own, I guess, their own spokesperson. They would be they would basically be individual pro se litigants in this matter, unless they hire themselves an attorney.
Thank you so much. Any
So
yeah,
could
please.
I ask a question about that, just for clarity? So if we hire an attorney, and certainly we need time to seek legal representation, we were actually hoping to have legal representation for today. However, all the land use lawyers, well, it was a time issue, but also when we talked with lawyers, we were told they had conflict of interest. So we'll probably have to go outside of Asheville to find a land use attorney that does not have conflict of interest in this case. And we are prepared to do that, but we need more time.
Sure.
Once again, you all need to, before, even if you had an attorney here today, the first thing needs to happen is that you establish that you have standing. The second thing is that once people establish standing, then they can make the request to continue this case. But if the continuance is denied, then you all, whoever has been granted standing, needs to be able to move forward with the case. So that's kind of how we're doing. So right now, the only issue is whether you have standing, and then we'll address the other applicants.
And that's all true. And also to dovetail on that, your choice to hire an attorney is your choice entirely, of course. But on the particular topics that are alleged as special damages, those topic areas will need expert testimony individually from those experts in those fields. That's what I'm talking about. So,
okay.
I think
I'll make a motion.
Okay.
I do not believe she warrants standing.
Okay.
I don't think anything special above and beyond any of their neighbors.
I second.
There's a motion and a second. Is there discussion on that? And I would say, just assert this one. Yeah, please.
I'm not exactly sure if this is appropriate, but let me ask Andy. Based on, I'm sorry, Kurt, something you just said. We have 3 applications for standing, I think. If, and entirely conjecture, if we turn down all 3 applications for standing, can somebody still say they want a continuance, or that's not possible?
No, I don't think that unless they are a party to the action, right? Because standing is basically establishing that you have some type of jurisdiction. Okay, so it's the litigant establishing that the court has jurisdiction. That's usually where standing comes from. So if the litigant can't establish standing, you all can't really hear anything that the litigant has to say. They can't participate as a litigant. They would be able to testify as a witness, but that's a little bit different. You know, they could basically state their piece and sit down, as opposed to, if they have standing, they can actively cross-examine witnesses, ask questions, and present evidence.
Okay, because here's the problem that I have, and I don't want to take up too much time on this. I think the applicant has incredibly good questions. I am seriously concerned about the issue she's talking about. And speaking personally, not speaking for the board, I absolutely believe that she should have time to find expert witnesses to come in and testify, because in my opinion, the 3 weeks she's had hasn't been enough time for her to do that. And what my temptation is almost irrespective of whether or not I think she legally deserves standing, I would vote to give her standing only because I really, really, really believe that her neighborhood, even if it's speaking on one person's behalf, I don't really care. There are serious questions that need to be answered. And it just seems to me that because theoretically, one or more people might say she standing by herself isn't the only person who suffers.
She's not special. And the
Okay,
other thing is,
No.
Craig has offered that she can be a witness, so she can ask questions
At the witness.
at the witness portion.
Yeah, if
Right,
I
but
could
can
just.
she bring witnesses in? Can she bring special witnesses in?
No, I
Well,
don't. She
well,
would.
that's the
She
whole
would
thing.
not be acting as a once again as
So
an
So on
advocate.
this vote, just real quick, on this vote, you've got to look past all that, the desire to want to hear those topics from this individual, because what matters in this vote is has she alleged special circumstances, and do you believe that she has standing as a participant in the matter? She's alleged special circumstances at this point. In the past, we have considered that, as proof, as evidence, but there hasn't been any expert testimony at all yet, and she's not supposed to present it yet. She's supposed to present it during the hearing.
And she won't be able to
And
present
I
if we don't
think
grant
that-
her standing.
Correct. You have to find that her property is particularly impacted.
But she's
Oh,
not
wait,
unique.
apart from her neighbors.
She's not unique to
This
any
one.
of her neighbors.
She still has to fit within the category.
Right. And I think that you can take, once again, I don't think that you have to have a preponderance of evidence in establishing but I mean, there has to be a basis of special damages, once again, an injury in fact that is something that is concrete and particularized versus, and that is actual or imminent as opposed to something that is hypothetical. The injury would be fairly traceable to the concrete or to the development or the use of the concrete plant, and that it's likely, as opposed to being speculative, that the injury would be redressed by a favorable decision. So if you denied the permit, that whatever alleged injuries would not be occurring. Does that help at all?
Well,
I mean, I'm using
it helps, and
the
again,
Supreme Court's definition of standing. So
Yeah, no, it helps, but, and again, I apologize if anybody thinks I'm dragging this out. It seems to me that the applicant for the special use permit can bring anybody they want in, any experts they want in to say whatever factual evidence they feel they have. But all of the neighbors can't do that unless one person suffers something that all the
Well-
other people don't suffer. That
Well, I
doesn't
mean,
seem
it's
right.
also possible that the neighborhood could, or a group of people, we've had groups or homeowners association, we've had other people come in and organize things. And once again, they could ask standing on their behalf and there would still be the same task. But right now you
Okay,
you
but
need to
presumably
focus-
she didn't know that.
Well, no, I
Right.
totally get it. I totally get it. And there's a balancing, but I think that the law in the North Carolina state legislature specifically outlined, more or less, or what's standing. And Craig, did you have something? Or
Yeah, I just want to chime in. Paul, I hear what you're saying. We have a rule of law here that's imposed not only by the courts, but the General Assembly has defined it as special damages to have standing. And that's what we're all faced with, is having to apply that. And if we just say, well, that's not fair, or then we have the slippery slope that variances don't matter and the rule of law doesn't matter. The reality is the burden is with this nice lady to show special damages. And I don't believe just in the idea of special or unique that she has demonstrated that. As I said before, that doesn't prevent her and others from asking the questions. This is going to be a fully transparent proceeding. We want to be able to answer the questions. To your point, when they ask the questions, you as a board then look at your standards and say, have you, applicant, answered those questions to the satisfaction of the standards in your ordinance? And your commissioners, again, have set the rule of law as to those standards. And so you will be, in effect, a guardian of the very questions that I'm assuming is going to come from the people behind me. Okay? So do we need a lawyer from Chapel Hill to come in and do that? You have a role where you can ask us the questions and we need to provide you information. So this thing always gets into a situation where we increase the economy by getting more lawyers involved. And so that we can basically, where they're wanting us to not be able to use our property and we want to be able to use our property. And I get that. But at the end of the day, you as a board can ask questions, listen to the questions, and make sure we meet the standards in your ordinance. But standing is the first step. It is this is not cart and horse. And she hasn't demonstrated standing.
So, real quick, one more question.
there is a motion and a second on the floor. So I
There
want
is,
to
we're in
make sure.
discussion on that motion, I believe. Yeah, one more question, or two, I think. Are you aware of any conversations with the HOA, directly HOA board, about this case and about potentially coming as a board?
We don't have an HOA.
You don't have an HOA?
No, sir. I have a quick question. May I ask a question? I was wondering, do the damages have to have already occurred?
No, I think that it doesn't have to occur, but I think that they have to be actual. As I use the words actual, or that they have to be concrete and particularized as opposed to hypothetical damages. So you have to be able to show that somehow that this concrete plant would cause a reduction in your property values, or that the concrete plant would cause damage to your property. I don't think you have to have actual proof, but I think just, merely saying, I think my property values will go down in and of itself is not enough.
Well,
But
if I may say,
proof later, we don't need proof of an effect. We need proof that it may affect during the hearing that comes up.
Right.
With all due respect, I think I may be more liberal in terms of standing than you, Kurt. The easiest thing is the uniqueness in whether they're special. Okay.
Right.
And that she admittedly says, I can't tell you that I'm special.
I'm not
And
sure I said
you couldn't answer the question. You did say for traffic, you wouldn't be special because
No,
the
for
greater
traffic,
community, but you couldn't say I'm special for anything else. And that is an element. And so, just on that alone, there wouldn't be.
Thank you.
That's to hopefully create an understanding. If there were only one well within a half a mile of the site, she was the owner of that well, you probably would qualify for special standing. Because it's unique to you. But there are dozens of wells. To his point, this council exists, this board exists to be that voice for all of you in questioning and challenging what this applicant is going to bring forward. And then to respond to how you as a witness pose questions to them and how, more importantly, they respond to your questions will influence the members of this board.
Thank you.
Unless you are unique, you've got to trust this board to do the due diligence.
Thank you, Craig. Joel, do you have anything?
Yeah, this for Kurt. Question came up about trying to find legal representation. And I'm sure holiday season may have had something to do with it. So the question is, if she's not granted standing, there's no sense her seeking legal counsel?
Once again, you're kind of asking me to provide legal advice. But legal advice to somebody that is not my client or is not my client. I represent the board. But to try to answer your question, if she is denied standing, she could they still have the option to seek out legal counsel, but they could not participate in this hearing. Now, it's possible they could appeal if the board decided to grant the concrete plant. They could try to appeal to the decision to the Superior Court. But once again, the initial question in order to get into the appeal would be, do you have standing? So we're kind of addressing it here, and so you're kind of not allowing people who clearly don't have standing to participate in the hearing at this point in time, or at least as litigants.
That answers that, I think. Yes, ma'am.
So with regard to special damages, I won't prolong this, I promise. But, if my well is damaged, no one else suffers for that. And I see that as unique damages. Nobody else around me cares if my well goes out. No one else suffers if my well goes out. Only I suffer, and my dogs, if my well goes out. We are the ones that experience that. That to me is special. I don't see why that isn't special.
So while I agree with those prior comments, board member comments about those properties that might be closer in to the site being affected more, I think the neighborhood as a whole is affected. But the discussion around the fly ash, potential contamination, and the potential property damage due to the water table and possible well issues and property value impacts, I think there is a possibility that we've heard from this applicant for standing that her property could be impacted differently than the neighbors because of her proximity to the property. Now, that could apply for a number of properties at varying degrees. Because if we see an air quality study that affects certain lots more than others, that collective group could be affected more. So we don't have that answer yet, but I think that's been alleged here. So I'm leaning towards making some determination on whether, internally for these various standing applications we have, that some lots that are closer in may have an impact greater than the rest of the neighborhood.
I would just suggest that you take each standing application on a case-by-case
That's
basis.
me too.
But yes,
But for those that are here and asking for standing, if they are proximate by a certain degree, whatever degree we establish, or vote to.
I completely disagree.
I just think that there is a motion to deny it and then to deny, your motion, Catherine, was to deny standing.
My motion still stands. I don't think she is unique and special enough to grant standing, and I think she'll make a great witness. I think she'll bring some great points to the table. I think Paul, your concerns can get answered, and I hear, Craig is offering to give her the open mic opportunity. So I really don't have any concerns about this.
I agree. I mean, we're talking about, hypotheticals now and, woulda, shoulda, coulda, and, my heart and compassion tells me to do this, but I don't think the fact that the language is very simple from the legislature and our commissioners, because they're dealing with very simple people, this is the measure. And it is in layman's language, and it doesn't give much room for, well, I want to, or can we conjecture into the future about, whatever it is. This is the test.
And that is to allege special damages on behalf of the applicant and to determine that they differ from the other property owners in some way.
Let me ask
Yes,
you this-
Jeff.
this if I could. By denying somebody or anybody else standing, that doesn't affect their ability to bring lawsuits for damage that they incurred, right? It's just.
No,
affects their ability to have standing in this.
No, I don't think that, and I don't think it prevents them from, if they wanted to appeal the decision, but they would still have to go through the hurdle of proving standing before Superior Court. But yes, no, that,
Cause of action.
no, all the standing is whether they get to participate in this hearing as a litigant at this time.
Other thoughts? Other thoughts? Yeah, we do. Before we do that, real quick, I'm going to just make a statement. I think each board member has to decide whether each applicant for standing has standing or has proximate possible impact related to their neighbors. I'm going to side with the denial here for standing because I believe that the employment district buffer to the open use provides some extra protection here to this particular property. I think I would feel differently if there were a standing applicant on a property that directly bordered this property, as we have indicated on our map.
And to
So I'm
look
gonna
at
get
it,
no, but I will.
it's like she's number 2, right?
Right.
So it's like she's got a lot of buffer.
Without creating an invitation there, but that's where I'm drawing the line
I
here. is
still
that I think
hold
you should
the
buffer.
doesn't hold standing.
Yeah, so there's a motion and a second. Without any further discussion, all those in favor of the motion to deny standing, please say aye.
Aye.
Any opposed, nay? The motion passes, standing gets denied. Thank you very much. And
Thank
we
you.
encourage you to stick around for the end of the hearing when we'll open up to public comment and allow for some of that testimony. Thank you so much.
Thank you very much to all of you.
And our next applicant for standing. Real quick, Griffin, who do we have on file?
Ma'am, could I get could we get a copy of what you submitted, just because?
I don't think she submitted it.
Oh.
Yeah, it wasn't fully.
Well, you were
She submitted
you were cross-examining
She
her
submitted
on-
it to me.
Why, I'm gonna just put that on the record just in case. So yes,
All right,
we'll make a
exhibit
copy.
So who do we have next?
We have an application from Danny Buckner.
Buckner, if you're here.
I think most of my issues I had have been covered, so I withdraw my.
Or will be covered. Thank you, sir. And our third name,
And third is from Joseph Daniel Norris.
Mr. Norris.
Oh, wow. Do you need some?
We can bring that to you if you like, or however you want.
Yeah, let's.
Like whatever combination you do.
Oh, there's a seat there.
You can have this one. You want this one?
Please.
Welcome.
Please raise your right hand and state your name.
Joseph Daniel Norris.
Do you swear or affirm to tell the truth and nothing but the truth?
I do.
Thank
I
you.
swear. I think, though, I will sit at that table. That's okay.
Sounds good.
So how do we begin? This is a, can you hear me?
Yes.
I think this mic's not hot.
Okay.
I think it is.
It is, it's just soft.
If Joel can hear you,
Just soft?
then you're fine.
Okay. So to begin, I've been learning as we go. This is my first time here, and it's not something that I thought I'd be doing, but nevertheless, I appreciate the opportunity to speak to volunteers in the community, and I appreciate what you do for the county. It's nice to know that we have this type of resource to consider these matters. So thank you. I'd also like to state that from the website, there's an infographic, and I just wanted to reiterate the charge of this group was to demonstrate that the development will not affect the health or safety of persons in the area or surrounding properties due to noise, vibration, odor, or glare, and will not be detrimental to the public welfare or injurious to property or public improvements. Now, I assume that you have that charge and you will be considering all those things. Is that correct?
Yes.
Okay, I just wanted to verify that. So we've learned about party of standing, and my property is one that adjoins the quarry in the area where the proposed concrete plant will be going in. I checked two boxes on my form, and I said I will suffer damages as a result of proposed action that this subject of this hearing specifically. And while the information is based on circumstantial information based on what is being proposed, based on the questions I'm hearing, not only from the board, but also from Mr. Justice, the legal counsel, which we don't have, we're at a severe disadvantage. It kind of feels like that there's a lot stacked against us as a individual applying for standing. But I think that what you're probably trying to do is get to the meat of it and get to the information so that you can determine if I am a party of standing. Okay, great. So, so procedurally, I think that I'll just read my statements and then we'll take a motion to see if I apply, correct?
Yes.
Oh, okay.
Excuse me, just for clarification, can you get a copy of the map and you could tell us which number lot?
Yeah, let's do that.
Yours is?
He's 6.
6. Okay, thank you.
Yeah, thank you.
Can you just confirm that, Mr. Norris?
You can have that.
Yeah, Mr. Norris, can you just confirm that you are lot number 6?
I'm lot number 6, and I
Or-
also own the adjacent lot that's right beside number 6.
This is on Exhibit A that we've tendered.
On the
Right.
right or the left of 6?
So the 6 is right here, Ms.
Right.
Morsani. It's right there. It does not have a number.
Is it
Right or left?
is it
It's on the
Oklahoma shaped
left,
lot?
right? Is what
So
you're,
if you're looking at this page, it's on the right.
On the right. Okay.
Okay.
so up against the green,
No, it's not up against the green. It's up against
That's
the
the
blue
right.
line. Look at
Okay,
number
so it's
6.
to the
Look at
left.
number 6.
and then
Yeah,
go to
yeah,
the left.
okay. And then it's to the left if you're
Okay.
looking at it.
Thank you.
Okay.
Upside down Oklahoma.
Upside down Oklahoma. Call that.
Whatever helps you remember. So let's get right to it. And I'm sure that we'll clarify and determine if I apply or not. I will suffer special damages as a result of the proposed action that is the subject of this hearing specifically, because my family's home is in close proximity to the proposed concrete plant. utilize a well as our water source because the large quantity of water needed for concrete production and cleaning, it would adversely impact the water table, thereby impacting our water supply. There is also the danger of contaminants from fly ash in the water supply. There was no data provided on this by SCM in the informational meeting for the community when it was brought up. I will reference, this is an exhibit, this letter that I received in the mail.
Here, we'll just have that as standing exhibit number 2.
Okay.
You don't need to mark it. Or do you have a copy for Mr. Justice?
I have his application.
Oh, okay.
He's reading.
Oh,
basically
is
his
it
application.
attached to the back of the application
is.
online? You don't need to submit anything.
Okay,
sir.
all right, very good. So, but what I want to bring to your attention is this was not a meeting to inform. This was a meeting to discuss. It said a very high level overview. When we were providing contention against this, the onus is on us to prove that we're going to be impacted beyond how we currently are. And so how do we know what questions to ask unless we're going in just to find out, one, there's a proposed concrete plant coming? Wow. And then 2, how do we understand the impact that it would be on our properties as zone R1 families? So what we feel like is the permit process was being rushed through. We feel like that is that by design? I don't know. But it sure feels like that it could be based on the amount of time that was provided, the evidence that was being discussed, and how this meeting is set up where there's counsel here, where my neighbor was being cross-examined. We had no idea this is coming on. Frankly, it feels unfair. But I'm going to go ahead to the next point so you can see if I'm a member of standing. The damages that will suffer are not distinct from those damages to the public at large or unique. They impact the entire community specifically. And my property value will be negatively affected with the industrial concrete production in close proximity to my home from the increased noise pollution from industrial production and additional truck traffic on Goldview. Transport of industrial chemicals such as fly ash used in concrete production in close proximity of our home would further impact residential home value. Now, Mr. Justice presented a great case. In some ways, I feel like I would be taken to shreds and have to say no contest because he made the comment, so you just did Google research. Well, yes, that's what I did in 3 weeks working full time. How else am I going to get this information? Where's the hydrologist that I get out in contact over the holidays? Where is the attorney that might be able to advise us? Where is the information of transparency coming from SCM to actually provide us with the information to see how we can help? Sorry, you yawned.
No, I'm sorry. It's my lack of sleep. Sorry.
No, that's okay. But that's my evidence. I don't know if I'm a party of standing or not. You've heard what I had to say, and you will make that decision. I love where I live. I care about it as all the others do. It's subjective information, but I just wanted to let you know that as a board, we are counting on you to protect our property rights and the quality of our life. We are at a point where after Helene, there's a lot of rebuilding going on, other things. We need aggregate, we need concrete, we need those other things. But we're also at a point where our community is being affected because of the overlap of industrial use as it is in close proximity to our homes. So I hope you weigh all this in careful consideration as you move forward in determining if you will grant this permit to Southern Concrete Materials and working with Hedrick and the others. We have 2 industrial locations, as Mr. Phillips, Weaverville gentleman said. I was aware of that when I bought my home in 2001. But do we need another one? I mean, is 2 okay? Or do we have to allow permission because it is open use so that we can be even more encumbered, more trucks, so that concrete can be produced, profits made, and residents suffer.
Thank you so much. Mr. Justice.
Yes, Mr. Norris, we've, looking at the map, you agreed that you own property that's number 6 here on this Exhibit A. Is that where the house is?
Yeah.
Okay. And you, because I was going to ask you this question, but of course you knew when you bought your property that you were next door to the Hedrick Quarry. Yes?
Yes, they are. In fact, I've used them. I buy gravel from them and use them for my own use.
I do too.
Yeah.
And did you know that the asphalt plant was in operation as well in this quarry?
Smelled it first, and then of course.
Did you smell it before you bought the property or after you bought the
No,
property?
you're asking great qualifying questions, and that was we were in full awareness that those two items were.
Okay. And you would have to agree that looking at Exhibit A, the quarry and the asphalt plant are between your property and the proposed concrete plant, right?
Oh, okay. This asterisk, is that the site, Mr. Justice? that's
Yes,
showing
sir.
Where it's going in?
Yes.
And would you please repeat your question so I understand?
You would have to agree that between your property and the concrete plant site is the quarry and the asphalt plant.
Based on my understanding of the geography, it appears to be so.
Okay. So it looks like when you bought your property around 2001, you paid roughly $150,000 for it.
It was a great deal at the time.
Sounds like a great deal
It's not
compared to
even sounds like
Mrs.
it was very good. Yeah.
Mrs. Sobin bought hers in 2021. It was over $700,000. You heard that testimony, right?
I like your leading questions. What is your point?
My point is you did hear that for her property, which is, as the crow flies, on the other side of the street, she bought hers for over 700,000.
Sure.
You admit you got a good deal. So would you also admit that your property values have in fact gone up over the years?
I think that everyone in Buncombe County would know that property values have gone up since 2001. The market has dictated that.
All right. And this is the case, even though that you live next door to a quarry where there's an asphalt plant. Yes.
Yes.
Okay. So on the application, you filled out this application for standing, is that right?
I did.
And you checked the box where you admit that your damages that are being suffered or claimed to be suffered are not distinct from the public at large, right?
Or not distinct. So
That's the box you checked.
Well, help me, Mr. Justice. You're an attorney. I'm not. And this board is here. This form was made for the public to fill out, but yet it's difficult to understand on such short notice, actually, if we are filling it out correctly so we can participate in this process. It seems a little bit foreign to us because we haven't done it before.
Well, that's fine. My question was, Mr. Norris, did you check the box or did someone from county staff check the box? Is that your check?
No, okay. I see what you're saying. Oh, that's my check.
Yeah, okay.
Yeah.
All right. That's all the questions I have.
Yeah.
On your addendum 2 on the application, past your bullet points says we need time to engage traffic engineers with the DOT, collect traffic data, and consult with real estate appraisers regarding these issues. I would assume we could add well and water quality issues and noise possibly to that list. Is that your intention to gather experts to testify during the hearing?
Is that our intention?
Is that your intention to provide that evidence?
Well, it depends. I mean, that's our recourse. We're in a situation where we are, our hands being forced. And so to gather that data to provide evidence that our area would be impacted negatively, we'd have to have evidence. And I think what we need to know as community members is, how does that work? How can we know what to do? Is the county prepared to provide resources to help us so that we know how to engage in a situation where clearly there is a lot more on one side than it is the other. I mean, the
Yeah,
honest is. the
We're
honest
going through our
background.
typical process that we go over for any
Yeah.
other case. So everything's been done appropriately and with appropriate timeframes. Of course, over the holiday, that's what it is. But you have a right, of course, as a neighboring property, asserting standing in the future if the HOA comes. Anybody else could be impacted. They can come make a claim to that effect and assert standing. The board has to determine whether that party has standing. And so in order to do that, we have to hear from you, and we already have today, that you've asserted special damages related to those areas here. If we grant your standing application, you participate as a party in the process, cross-examining witnesses from this side and everything else, and you don't end up bringing qualified evidence or experts, the board could not weigh your that lay testimony as the same as what the applicant is presenting.
I agree.
So that's
Yeah.
what we're
That's
trying to determine here ahead of time, whether or
Sure.
not you're
And
planning
so
to bring
whether I
that.
have
If you're not
understanding.
planning to bring that, we can't consider lay testimony.
One other thing, Mr. Chairman, if I might add, if you tend to go with your hard stop, which is typically 4 o'clock, is that right? Yeah. So obviously, because of that darn variance,
Yeah, it won't be today.
this is going to roll over. In any event, it will roll over. Okay. So I would say to everybody behind me, including this gentleman, that we can have another community meeting. They could bring whoever they want to ask the questions, and we can go through it again. Apparently, they didn't get the answers they wanted. Maybe they weren't complete enough. We can do that again between now and the next hearing. But again, we're talking about a rule of law about standing that is there for a reason, that is the horse to everything that follows. And with all due respect to this gentleman, his situation is no different than the previous applicant, and he on his form even admits and checked the box that my damages are not unique or special or distinct. So here we are again.
Just a point of order. I do want to say he checked both boxes. So he checked both the one that he will suffer special damages, and he also checked one that says, so he checked both boxes. I want to make sure that the board's clear on that.
No,
It's
the box, there's a box he could have checked that said the damage I will suffer are distinct.
I will suffer special damage as a result of the proposed action.
That's
This is
one question. The second element to that is, am I different than everybody
I
else?
get. Well, I'm just wanting to make sure that multiple boxes were
So
checked.
looking at that language and those check boxes, is it your contention today that you do suffer special damages, or would in these areas that you mentioned, separate and apart from those that your neighbors might face?
Quite possibly, but it's inconclusive right now, only because I feel like my property is very close. I mean, if we go back to the map, it's right here. You got the backwards Oklahoma and the other. It's right there on the border. So it's close proximity to operations. It is here, but I think what we're to answer your question, I don't know. I mean, what? So, I mean, none of us know.
But you think, I'm hearing that you think that your property individually could be impacted more because of its location closer to the site versus somebody down the road, say on, can't read that, Rice Meadows, for instance, someone else down the neighborhood.
And here's why it could. When you're closer to something, you hear it better, right? So if I'm closer and there's more noise, and I place my home on the market for the market value, it's not the 2001 value that was presented, but the market value of today, and they heard that loud noise and declined to offer, would that not put me in a place of being adversely affected because of my location in relation to the plant?
So to confirm that, and also the addendum 2 language you have here related to needing time to consult with professionals regarding those issues, including an appraiser perhaps and a real estate, those officials. are you planning to bring that evidence to the board?
Well, I mean, so,
Mr. Chair, I would think that probably the correct thing to do would be to determine whether he has standing. Then if he has standing, he can either ask for a continuance, and then if he wanted to get the extra witnesses, he would need to do that.
I'm just trying to.
No, I get what you're saying. You're trying to say that basically what we're trying to say is that if you are granted standing, you would basically be acting in the same position as Mr. Justice, which you would be responsible for providing expert witnesses to substantiate your case. You would essentially be acting as that, whether
If you didn't bring those professionals or the board found that it was lay testimony, it wouldn't be counted.
Exactly.
As the applicant.
Yes.
So you would be discarded and all that time and that
Yeah,
effort
sure.
and everything, you see?
So,
we're trying to
in many
verify.
ways, yeah, I think those are great qualifying questions based on how you're educating us and my other neighbors. I think that I have to say no contest to that because it would be difficult to do. So therefore, it seems like I need to disqualify myself of having standing. But I need to be careful because I don't have legal representation. I might be saying something that if Mr. Justice was on my side of the table, he's like, don't say that. That's dumb. You're putting yourself in a very vulnerable position. I don't know that because this is a form that was created that we've never seen before. And I need to be careful so that we're, as a community and as a homeowner, we are positioned to have recourse. Does that make sense?
it does. But once again, if you are applying for standing, you are applying for yourself. You cannot, you cannot represent your neighbors. Okay. That would be considered the unauthorized practice of the law. But if you have standing, then you would be able to, let's say, hire a lawyer to present your case. You would be able to hire witnesses and present your case to the board. If that's really all we're trying to establish right now.
And if that's not the route you want to go, we can.
Yeah, and if you don't want to do that, then you don't want to have, then them granting you standing is either moot because you're not going to present any evidence. So either you are going to be the one presenting evidence in this case in opposition to the permit, or, you could be a witness where you could ask the questions, but you would not have the same ability to present witnesses and ask questions of the applicant's witnesses.
So just to clarify, I'm very concerned about party status, clearly. But I'm only concerned to this extent because that is a legal threshold that bears to the jurisdiction of this board, as your lawyer said. In terms of the ability to speak, ask questions, participate, I'm saying again that he would have every opportunity to do so because we are wanting to do that from a standpoint of transparency. He has been asked and he has answered, and you say, well, should I have done that? Personally, I just want you to speak the truth. And so to the question of, am I unique? He said, no contest. I can't really say that. At the end of the day, again, they will have every opportunity, and it's up to this board to make sure that the standards of the county are followed.
Pretty straightforward.
Can I make a motion?
We got a question first.
I got a question. Yeah, this is for Kurt, more procedural question, because twice it was brought up by those seeking standing about the notifications. And was the notifications regarding this case within the allotted time limits? Do the holidays have anything for the notification times?
I believe I'm going to defer to, I hate to punt, but I'm going to defer to Savannah because staff usually takes care of sending the notices.
They were sent within the allotted time. I believe asked to be 10 to 25 days before the hearing. Yes, so 10 to 25 days before the hearing is the allotted time in which we can send notices, and they are within that time frame.
There's a motion. There's a proposed motion.
I make a motion to deny standing.
There's a motion to deny. Is there a second? Second. Any discussion? All those in favor, please say aye.
Aye.
Any opposed? Okay. That passes. Standing is not granted. Yes, thank you very much. And right. Thank you very much. Appreciate it. Moving to any other applicants for standing in this matter? That's all we're listed, yeah. Anybody in the public wish to start standing? We'll start with this gentleman here, then Vlad.
I just have a quick question. So you're saying the Woodland Hills owners all need 204 attorneys to determine if each of us have standing individually?
Each resident.
204 homeowners in our community. Each of us need a separate attorney to represent,
No.
to see if each of us has standing.
We're in fact saying the
Because
opposite.
We're not allowed to.
We're in fact
represent
saying
our
the opposite.
neighbor.
We're in fact saying the opposite.
No, but the thing is that you as a layperson cannot represent somebody else. Okay, that's more of the unauthorized practice of law. That's not a question. But if the homeowner association wanted to assert standing and they could establish that one of the members in the homeowners association had standing, they could do that. But you would need an attorney to present that. You could not, like your president of your board basically can't act in that attorney capacity in representing somebody else, whereas you can individually represent yourself. But if you were going to be advocating for your neighbor and specifically dealing with your neighbor, that would not be, that would, once again, you'd run into the unauthorized practice of law issue.
Representing for ourselves and nothing. So one attorney could represent 204 homeowners in Woodland Hills, correct?
That's correct.
Well, if it was an HOA or,
If the HOA.
yeah, right, they don't have an HOA.
Well, if it was established, if it was a group, but once again, we're not, that you would need to establish, this is the time to be establishing standing.
And since I just heard about this meeting 48 hours ago, didn't know about a concrete plant until 48 hours ago, I would still have time to hire an attorney for 204 homeowners.
Not today, obviously not today, but all the notices have been sent out in appropriate guidelines.
I didn't get
So,
one.
are you in the perimeter?
I pay taxes.
Are you in the perimeter?
$3,300 in
effective?
taxes.
Okay,
a week ago.
then we're gonna move on, sir. Thank you. I'm sorry, man. We have
Once
one
again-
person over here that asked to.
Does anybody have standing, or does anybody want to try to assert standing at this period? Because this will be the last chance to do that.
Hand raised over here. No? Okay. Yes, sir.
So I have the form, and this one gentleman wasn't really sure about exactly what standing was, or he had some questions about it. And I appreciate the fact that he was willing to look at this thing a little closer. Can I approach?
Are you going to be I'm
ahead.
I'm sorry, Andy. I don't mean to be jumping on you.
Let me take it over here. Are you asserting Are you planning to assert standing on your own in this matter?
I have a hearing problem, so I'll either.
Okay, come up here then if you can. Yeah, if you need to.
Yeah, sorry about that, Andy. I wasn't mean to be
Uh,
jumping on you.
So
Yes.
this is the form that we're providing.
Yeah.
Okay, and the way that it reads, it says a person. There's really no room in there that says a person or a committee or a group of persons with one single point, right? The language in here says one person has to show a unique, and by the way, I am also a joint property owner to the quarry, and I have no problems with them. And I bought the house 15, 20 years
So without
ago.
getting into detail, I'm sorry.
Yeah, sorry.
So on the standing issue, yes, you have a right to appear and ask the board for standing in this matter on
As
your
a
own.
group.
On your own.
You're aware of that?
No, I am.
Sir, we've seen it.
Totally
Yeah.
aware.
You're able to approach on your own and do
Right.
this. Yes,
Yeah.
just as those two applicants have done so far.
Exactly.
And the HOA, if there is one, can hire an attorney to come and present a collective effect of the
Okay.
the issue.
And would that committee have standing?
If they were formed as an HOA and had hired an attorney, they could appear here and assert standing for the neighborhood.
And I'm not saying that I want this, but we haven't been provided the time to actually create this group.
Sure.
And Chris Sylvan, who
Sure.
was the first person that rejected, has spent a great deal of time trying to get a collective,
Right.
group together. And we had an excellent meeting with the Kindred people and with the, concrete people. And you've got most, if not all of our questions answered. There are a few with regard to the water and, you know, the dry answer that we have. But my question is, if no one else stands up at this point, then this is over, we're done. Opposite of what, again, I appreciate your time listening. We heard in the first long, you know, discussion about whether or not they should have an adjacent building on the property.
In the community meeting? Yeah, that's outside this process, yeah.
The meeting before, the group before us. Well, in that, the sense of the law was, we're gonna protect all the property owners around that and not make this one person have the ability to come up with some unique situation. Now the law is flipped around and.
It works both ways. You can individually get representation if you want to as an
Yeah.
individual homeowner,
Right.
or you can collectively form an HOA and hire an attorney and come forward with a case that's collective for the whole neighborhood,
Okay.
if you want to.
So in the first, group that we saw, thanks again.
And we have no idea, we don't know about that process. This is the hearing on the actual case. So
I just have to interrupt and say that at least my understanding is that this meeting is for the purpose of conducting the hearing, not the purpose of educating people on how to participate in the hearing. And there are resources available for those who want to learn how to participate in the hearing and what the law states and so on.
So planning office can answer any questions that y'all might have about this, but this process has been noticed and is ongoing here. So we're in the process of the hearing. So we're here to see if anybody has standing or wants to assert standing in the case. And if they're not here to be able to prove that to the board or with an attorney as an HOA, this is the time to do that now.
Do you feel like we've been getting adequate notice and that?
It's not my opinion. We're following the county statute and the state statute. So I would recommend, sir, that you have a seat and let us proceed, and let's go ahead and call an attorney. Call an attorney is the next step.
I would have, potential standing is the reason I came forward. Okay, so I
If the
appreciate
board
your time.
were to find that, yeah.
Yeah.
And yes, ma'am.
I just have a question.
Please.
About us receiving the notices.
Yes.
I think they were saying what we were notified 25 days ahead of time.
Let's go through those notification steps one more time real quick for everybody. And everybody listen up and we'll make sure that we verify that.
Thank you, Chair. So board notices have to be 10 to 25 days. So within that time frame.
Mailed.
Thank you. Yeah, mailed within 10 to 25 days. So not 25, 10 to 25. Yes. So we are within that time frame for mailings.
There's also signs on the property as well. Yeah.
Yes, we have a picture of the sign posted on the property as well.
And then we're in the newspapers with public notices and we're on our website.
Both in the newspaper and on the website.
So all those ways are the ways we get out.
Yes.
And also mailings, direct mailings.
Direct
So those-
mailings.
Yeah. So, yes, ma'am.
Well, I was just saying this is postmarked the 20th of December. I did not get it till after Christmas. So that's not really.
That's the procedure. The law is established there. That's the correct procedure.
So 10 days. That's
10 to
within
25
10
days to
10
mail it.
days.
To mail it. That's the law. So let's talk to the commissioners about that if we have questions. Other folks in the audience wishing to assert standing, this is the second call for that and a third call for that. If the opportunity later on in the hearing after the case has gone through to for the board to choose to open up for witness testimony, which time you'll be able to come approach and make any statements you'd like to. At that point, the applicant can respond to those collectively afterwards. So, does the applicant wish to push forward today and start the matter?
Well,
or-
why don't we start with one witness, just as an overview, description of the application, that would be Warren Sugg. So, Warren?
Thank you.
You're not getting out of this
Mr.
easy.
Chair, I would recommend that the board close any standings so that if this does get continued, you don't have a new batch of people making standing applications at the next hearing.
I'll take that as a motion to close standing at the application at this time.
I'll second.
There's a motion and a second. All those in favor, please say aye.
Aye.
Any opposed, nay? Those are closed.
Thank you.
You guys need me to swear in again, or we're good?
Welcome again.
Thank you.
Make sure to use your microphone so Joel can hear you.
Yes. Can I take it out of here and just hold it?
Mr. Justice, any questions for me, or would you like for me to just?
Yeah, why don't you just introduce yourself, let them know how important you are in terms of what you do for a living and your background. We'll tender you as an expert in civil engineering, but just start with your introduction and who you are and what your background is.
Thank you. I'm not nearly as important as Mr. Justice. I'm Warren Sugg with Civil Design Concepts. I'm a civil engineer here in Asheville, Buncombe County area. I've been doing the practice of civil engineering for over 20 years. I've been here in the mountains for more than 10 years. I've been before this board and boards like it over that 10-year period, and been at those times considered an expert in civil engineering. I got my degree from North Carolina State University. Not good in athletics, but pretty decent in engineering. And if there's any other questions you have of me, of my background, please ask.
So Warren, you did fill out a written statement and signed a sworn affidavit.
That's correct.
Okay. Is this a copy of that?
Yes, it is.
All right. Mr. Chairman, I'd like to tender this to the board, call it as our Exhibit B. If that's okay.
Okay, please.
Warren, attached to your Exhibit B is a copy of your resume. Is that right?
Yes, sir. Under Exhibit 1.
Okay. Mr. Chairman, I'd like to tender this witness as an expert in civil engineering.
Hearing no objections, so tendered.
All right. Warren, why don't you give an overview of the project in terms of what's being proposed?
Yes, sir. So I was contacted by SCM to review the site, and we started with a site visit a few months ago. At that time, they let me know that they would like to put a concrete plant here. It was in the existing facility that is a quarry and also a asphalt plant, but this is a parcel or a part of a parcel directly adjacent to those uses. It is along Goldview. There's an existing driveway that accesses this project area. As you come in off of Goldview, one of the items that we talked about, both with the client and just in good keeping, was to widen the driveway area. There's a small gray area that's shown on my C201, which represents some widening there. You'll also notice there's the driveway kind of splits and goes right and left on C201. 201 to the right goes to the existing asphalt plant. To the left is the gravel area, which represents the entrance to the concrete facility. As you go from there, and if you were to go counterclockwise on the map here, to the south in green is the indication of where some septic drain fields would potentially be. We've got a soil scientist that has been doing an investigation out there, and will give the final permits and final determinations on that. First thing you get to in sort of the center of the site is gold, and it has dispatch on it. That is the 15 by 25 dispatch office with 2 standard parking spaces. As you move towards the center and where the gray upside down L, that is the concrete facility or the plant machinery. You've got a item in the middle there that is a dot with a dash around it that represents the potential well, as well as in blue there's also the storage tank that was spoken to just a little bit earlier for water storage. You'll also notice a number of different standard parking spaces, as well as mixer truck parking spaces to the south. In red on my sheet, there is a block farm 15 by 25, as well as a maintenance shop, 50 by 60 maintenance shop with a concrete apron, that so they can maintain the facilities, maintain their trucks. Just north of that, you'll see an ADA space, as well as a fuel storage area. And then as you work your way to sort of the 9 o'clock, 10 o'clock area of the site, that is where you see the proposed aggregate storage bins. These are the large areas where their different materials are stored. There's also 2 red rectangular areas that are their internal storage, like Connex boxes, basically for some storage there as well. We also have 2 settling pits to the north of the site and a mixer truck wash area. All of this is kind of bound between a couple different parcels. You see a dashed dotted line that goes through the middle that represents those 2 PIN numbers that are shown in the application.
So using Exhibit A, so this is the document we had tendered before. If you would just identify it with this red pin, put the asphalt where the asphalt plant is located.
Okay, I'm going to write the word asphalt on the asphalt plant.
All right, so generally speaking, the witness marked on this plan where the asphalt plant is located.
That would be generally due east of the concrete plant.
So on the drawing that's up on the screen, the concrete plant, the asphalt plant, excuse me, is adjoining or immediately to the east?
Correct. It would be generally living where the letters C, D, and C live on my page.
And looking at this Exhibit A, just generally describe the layout of the property between the folks that have, like the nice gentleman that just spoke. He was number 6 here on this drawing. Just sort of describe what's between him and the concrete plant site.
Okay. So property owner 6, property owner 1, property owner 4, all of these are to the south east of the parcels as a whole. From there, that is really the stopping line between residential R1 that you see in yellow, and you're starting to see open use, which is, I think you said earlier, just kind of a natural color or nothing. There's quite a bit of vegetation just due northwest of those parcels that we just spoke about. And then you start to, as you go along Goldview, get into more and more of really just the quarry all to the north, the asphalt plant all to the north, the subject property, which is, moving even further west. So quite a bit of unused open land, and all being accessed by way of Goldview.
If you would, for the proposed project development, if you would talk about sort of the buffering that's within the control of the applicant here.
Absolutely. So one of the items that came of some driveway research by our traffic consultant was some clearing. So there will be some necessary clearing on the south edge of Goldview Road at our driveway. Also on the northeast side of our driveway, some more clearing or moving of obstacles so that there's good sight distance. That is one side of the question of what are we getting rid of in order to make site visibility as good as it can be and to meet standards. But on our site, which is bound by Goldview to the south, we have quite a bit of vegetation that can be remain. It's roughly about 90 feet of existing vegetation buffer that can remain. I say roughly because those septic area will be the final determination on whether that one area gets a little bit smaller. But my C301 is a rough grading plan, and it shows you the limits at which we're expecting the grade to go, and everything outside of that would be maintained.
So just to stop right there, does the board have any questions about what we're talking about in terms of buffer from Goldview Road that we're looking to preserve? He did mention there's a sight line of vegetation right across the street on Goldview to assist in the driveway ingress and egress. But in terms of on the north side of Goldview where the plant is, does everybody understand sort of the buffer we're talking about? It's about 90 feet roughly. All right. Why don't you address utilities?
So like most of the neighbors have already mentioned, this area out here is absent of public water and public sewer. So this facility I've spoken on a moment ago will need a septic. It's a very reasonably small septic because there's only just a couple folks who will be, manning the spot and the occasional truck that's coming in and out, but it's not a large septic use. There will be a septic field there, and that will be done by soil scientists. There will also be a well put in, which I know has been much talked about, and there's an existing well. So it will be served just like a lot of our neighbors by well and septic.
Now, attached to the Exhibit B, your written report, you have a sort of a summary of the project, executive summary that's dated January 7th. And so this is part of Exhibit B. You talk about the traffic and the ingress and egress for the project development. Why don't you touch on that some more? I know we'll have James Vaso address that. But walk through the driveway and the point of ingress and egress.
Sure. So today there is a driveway there, and it's, as you can see, is at a very acute angle. So as you exit the site, if you were to look right, you're looking very steeply back to your right. To the left, it's more visible. We have added some extra pavement there to allow that truck to get a little more squared up to the intersection, like we would normally want to come up to that intersection. But in addition to that, Mr. Voso has also looked at NCDOT standards, and correct me if I get wrong here with any of the numbers here, but he's done some equations and looked at all the different studies, and we have to have, I believe, 560 feet of sight distance to the west, and we have to have at least 500 feet to the east. So because of that, and speaking of the vegetation earlier, we've looked, and that is the best way to ensure that while that driveway is there today and is functioning, that this is a way to improve it, to not only get trucks squared up to the intersection, but to also make the site visibility meet standards.
And you have created a drawing that shows the enhancements and improvements that are to be done to the ingress and egress to this facility, right?
Correct. It's C201 with the addition that I have added red hatched area that represents that area to be removed. And I believe that's part of documents to be submitted.
Okay. Do you have copies of
I
that?
have this one right here that everyone can have.
This is all part of James Bosso's.
Yes, sir.
Affidavit. So this, Mr. Chairman, this is just for now. We have a copy for everyone, but I know we're short in this
Day that we have less, but there was considerable analysis done to improve upon the driveway ingress and egress, and we will, as part of this application, condition our ingress and egress by the maintenance of a site distance preservation, so we can maintain site distance along Goldview. And so we've laid that all out on that drawing, but we're going to go into that with a different witness. Now, in terms of the well, your report mentions that the capacity of a well is approximately 4,500 gallons per day. Is that right?
Yeah, per speaking with the client on just their normal operations, about 4,500 gallons per day for concrete production was what we've determined.
Okay, but that doesn't account for the fact that the water will be ultimately stored in these tanks, and principally the operations will be drawing from the storage tanks.
Correct. Right now we're thinking around a 10,000 gallon tank on site. So if you think about it, that's about 2 days worth of production. And, that well and that storage tank could be drawn upon during off-peak times to have that storage there for the actual use. So where people may be concerned about usage during the day, it's potential that this storage tank could fill up in the middle of the night when there's very little water usage happening.
Okay. Mr. Chairman, that's all the questions I have for this particular witness, who's just giving really an overview of the project.
Thank you. Board questions for Mr. Sucker?
I want just the last comment, you said could be the hours of operation, could be. Are there no planned established hours of operation for the operating the well?
So we're going to have, there will be another witness who is the Southern Concrete person who will get drilled down, no pun intended, about operational questions. You have to imagine, Craig, that we all know with the hurricane, there's a lot of work going on. That's maybe why there's more trucks coming out of the quarry. Today, concrete's a very precious product, and the state often drives how often things need to be produced. But those are questions for the Southern Concrete representative who will be present at the next meeting.
So can you make a good point in his presentation to address that?
We will address that, yes. Yeah.
Hey, Warren, so you heard a lot of the neighbor concerns. What would be your response to us about that and how with your plan that those concerns could be mitigated?
Any particular, that we
No.
heard a lot of different things.
We heard a lot of different things. So like, I don't know, whatever you are qualified and willing to address.
Hold on. I just want to be sure. Craig, did you tender Warren as an expert?
I did tender him as an expert
Did the
in
board-
civil engineering and.
Did you guys vote to?
Yes, you did.
Okay, I just
Yeah.
wasn't 100% sure that we accepted him as an expert. So
And Catherine, to your question, the water issue will be addressed by the Southern Concrete folks with particularity. The truck ingress and egress also is a combination of the Southern Concrete folks and our traffic engineer. And then the fly ash is a Southern Concrete question as well. From a civil engineering standpoint, it's laying out the site, and I didn't go through, but his report did. There are stormwater conditions. There's all kinds of erosion control. There's all kinds of standards that are in front of us that I believe you have indicated in your report. We're going to meet all the standards of Buncombe County, correct?
Correct.
Now, as to the specific three things they've raised, we do have witnesses for that.
But I see, okay, so one of the things I'm seeing is like you're using the existing quarry stormwater pond, and you're utilizing existing things that are already there and not having to recreate. And, I don't know, but I'm thinking, from your presentation is you're able to reuse a lot of things that were already there from the quarry days to this use and not having to start new, but like coexisting, or it's like kind of things on top of each other, if that makes sense. I'm not
Yeah, I mean,
using
and
my
that's
words very well, but
yeah,
that's
that's
kind of where-
intentional. I mean, when I was contacted and I was told that we were talking about doing a concrete plant at an existing rock quarry and an existing asphalt plant, my initial thought before even knowing anything else is that's a great spot for a concrete plant, because there's already existing uses that are very complementary to what's already happening there. Whereas you typically wouldn't maybe want this on a green field in the middle of somewhere else. So it makes a lot of sense from just pure planning. And then the open use makes a lot of sense that, concrete plants are specifically sort of pushed more towards open use and some other areas. So it makes a lot of sense from that standpoint. From stormwater, yes, we have some on-site stormwater that we're trying to do. We're trying to not only utilize what's existing, but trying to mitigate what we have going on specifically to our site, and then trying not to push that to anywhere other than internal.
Well, to another example is the fact there is an existing well there that was part of the Austin powder that you heard earlier. And so we'll be utilizing that well in addition to the one well we're looking to drill. Is that correct?
Correct.
There is an existing driveway. It's already there that the asphalt plant does take advantage of, correct?
Correct.
So we'll be sharing those type of things. So you are correct.
And a good bit of this area is already cleared. That's where the project is.
A couple of questions, because I think you're answering them in an indirect way. Have you served in the capacity you're serving for this concrete plant project in any other prior concrete plant projects of similar in similar nature, or is this the first time you've done a concrete plant?
I have helped with an asphalt plant. I've helped with this concrete plant. I've been doing this for more than 20 years. Not many asphalt plants and concrete plants come up. So the vast majority of my projects are apartments, single family, commercial, all those things. But it's not something that's foreign to me, especially when we're talking about site development. We're talking about stormwater, water, sewer, grading, erosion control, compliance with NCDOT.
So to the point earlier where we got into the water, we're planning to bring someone forward that will talk about potential impacts to the aquifer or to the availability of water and the proximity
We will answer the questions relating to water. Correct.
and other things that would be specific to a concrete plant outside of the general civil engineering role
Oh, yeah.
that Mr. Sugg brings to.
Correct.
Forward.
This is a puzzle. He's only trying to fit in one corner of the puzzle.
I'm just trying to clarify that for not just the board's sake, but also members of the audience, that we're gonna have a lot of information.
Oh,
that's
yeah.
gonna come forward.
Mention an existing well, and then a new well is proposed here on the map as well. Where's the existing well?
The existing well is in fairly close proximity to the dispatch office.
Thank you. Other thoughts, comments, questions?
And the reason for not using the existing well, or will it continue being in use?
We'll use both as far as we know.
There's a domestic use component of office, flushing toilets, potable, and then there's also the industrial use. So there's two different uses. You will hear the storage tank, I think, will address a lot of the concerns about drawdowns, because we're not talking about daily drawdowns of X per day, because we have stored capacity to address that, which is different than Hedrick and other of the uses out there that are currently going on.
Any further questions for this witness? All right, I think we're all set.
You know, I could probably, if we're of the mind, because I could call John Palmer, who would touch on property, and probably be able to finish him by 4, if it's okay, so that he didn't have to come back, if that makes sense, Mr. Chairman.
That works just fine, assuming their last case is going to be next month.
Yeah, do you want to continue that right now so that then whoever's been sitting here waiting can leave?
Let's check with them first to make sure next month is doable.
Ledbetter? Yes, we're basically going to have the same agenda in February, so yes.
That would be the second case next month.
Well, you have the continuation of Emma Road, you have you have the Hendricks variance, and then you'll also have the concrete plant to finish up, so, yeah.
We can go in February, but our due diligence ends prior to that time. Is any ability to go?
Before that, no, there would be no ability today.
Well, do you think you can finish in 15 minutes?
Our presentation's 5 minutes.
I mean, and there's also, someone has applied for standing in that matter. That's not getting done in 15 minutes. I can tell you now. Yeah.
Okay. All right. I was trying to be nice, but okay. John Palmer's who we'd call next.
Mr. Justice, can I ask you a quick question?
Yes, sir.
Is the person who filled out the application going to be speaking today?
He just spoke.
Warren Sugg.
Oh, I'm sorry, you actually answered the questions on the application?
Oh, no. No, we haven't completely. A lot of at least what the neighbors have brought up are going to be through other witnesses. We
But
haven't.
somebody wrote the application. Somebody answered the questions on the application.
That's correct, but they gained the information from Southern Concrete officials and others, so they just transcribed the information on the application.
Do you know whether your question is about the application?
It is
itself?
specifically about it is specifically about the application for this?
Okay,
Yes.
Let's go ahead with that question then.
Yeah.
Make sure it's
Okay.
Warren.
Bring Warren back.
Warren?
Sorry, John.
I'm sorry, I wouldn't have thought it would have been him.
Yeah, sure, maybe it's not. I don't know.
Okay.
No,
Let's
it
hear it.
isn't.
Let's hear it.
Okay. The first question you asked, the first question on the application says indicate how the proposed SUP will not adversely affect the health or safety of persons residing or working in the neighborhood of the proposed SUP. And your answer is basically, the plant will not affect the health and safety of persons residing or working in the neighborhood of the proposed project. And I'm wondering if you consider that to be a complete answer to the question.
I put the proposed concrete plant is proposed within an existing quarry and production facility and will produce concrete that is used throughout Western North Carolina and will not affect the health and safety of persons residing or working in the neighborhood of the proposed project. That was the complete statement I put on there.
Okay.
And
I
in
will admit-
combination with
Okay.
speaking with SCM, I mean, this was filled out. I typed it in, but it was a combined effort.
Okay, I will admit regretfully that my question was meant to be slightly snarky.
Okay.
Okay. The answer you gave is basically what the question asked. It's the same words. You haven't given any more information in the answer than is the question. Right, the question says, will it adversely affect the health and safety of persons? And you say it will not affect, it says indicate how it will not affect the health and safety. And you say it will not affect the health and safety.
Of it being located in a quarry. Now, again, the quarry's been there since the 80s. And you heard this witness say that when you locate a concrete plant, the probably optimal place to do it is in a quarry. This happens to be near an asphalt plant. I hear the point, Paul, but if we were to give the complete answer, we would have pages upon pages, and
That's fine.
that's
I have
not.
no problem with pages and pages.
But the reality is that the hearing here is to solicit the information that goes to answer the
You're gonna
standards.
approve that statement. with
Yeah,
your-
this,
with your
oh, yeah,
witnesses, yeah.
Lord,
So-
yes.
So if there's a specific question related to engineering, related to the site map, engineering related,
Well, it's just basically,
Honestly, his answer is no.
no, is his answer, yeah.
And would you rather him just say no?
And he's.
well,
they're
I'd
gonna-
rather
they're
him
appro-
say, here's the possible way you can affect the health and safety, and here's how this will not affect the health and safety of each one.
They're gonna
It
have,
won't affect the
they're gonna
water of the
prove it.
neighborhood, for example.
they're gonna prove it with witnesses. With their coming witnesses.
Okay.
Yeah. It's not the
Well,
whole
first off, we're going to
conversation.
comply with every Buncombe County standard, every technical standard that exists out there, whether it's air quality, stormwater. So right there out of the gate, we should be at least halfway home. The law, whether it's good or bad or indifferent, the law from the court say these generalized standards, a lot of figuring it out needs to come from the opposition. Because once we show we meet all these technical standards, we're halfway home. But again, we have other witnesses that will get into a lot of the things and a lot of the questions that were raised today. So I'll blame Warren and Doc his pay for not giving a more
Bring it
complete
back next
answer.
month, just in case.
But it's rare that you would see pages upon pages of trying to anticipate what the objections or
I'm
concerns
trying to
might be.
get to every topical issue the board's got with each witness at a time, but in reality, we have to go back sometimes to hear back from Warren and folks that we have to go back to questions we haven't yet resolved. So, is that
Yes.
okay? Other questions, comments? Okay, let's hear about traffic.
John,
No, property
hopefully
values.
we'll not talk about traffic.
Property
Yeah.
value.
Hear from John.
Talk about traffic, won't begin.
Let's talk about traffic, John.
But he's not a qualified expert.
That's right.
Please raise your right hand and state your name.
John C. Palmer,
Do you swear or affirm to tell the truth and nothing but the truth?
I do.
Thank you.
All right, John, if you would introduce yourself to the board and talk about your qualifications.
Yes, my name's John Palmer. I've been before this board before. I'm a designated MAI appraiser. I'm a CCIM, which is real estate. I'm a review appraiser and a couple other things. I've been appraising for close to 25 years now. Been a realtor for 48 years now. I've appraised all different types of properties all over pretty much 4 states now. I've qualified in Superior Court, District Court, lots of different types of boards, commissions, and things like that.
And have you been qualified as an expert in front of this board?
Yes.
Okay. And have you prepared a written statement in the form of a sworn affidavit?
Yes.
And is that a copy of it?
That is.
All right. Mr. Chairman, I'd like to hand this up as Exhibit C, please.
Quick, we can get it.
All right, John. What were you asked to do relating to this project?
I was asked to examine the site and see whether I could determine whether there'd be an adverse effect on the surrounding property values.
All right. And Mr. Chairman, I'd like to tender this witness as an expert in real estate appraising.
And no objection set to the.
All right. And so Exhibit C is the culmination of your work and study. Is that right?
Yes.
Okay. So ultimately, on the first page of this affidavit in that you're swearing under oath, you address two particular standards of the Buncombe County zoning ordinance, correct? They're in paragraph 7?
Yes.
Okay. And for these conclusions that you have made, if you would walk the board through your deliberative process, your analysis, the facts, and how you came to these conclusions.
Okay, I was contacted to basically try to determine whether there'd be an adverse effect on surrounding property values based on the land use that was proposed, which was a concrete plant. So what I did was I looked to see whether there were other types of concrete plants, and I had to see if I had enough data to be able to show whether there was actually a detrimental value based on residential values. I started with actually the site because there's an existing quarry that's been there for a while. So my thought process was that if there was going to be any kind of a damage based on what's there now, it would show up in that study, and that's comparable number one. I then identified other concrete plants. There were 30. I think, in North Carolina and South Carolina. And I basically whittled them down to these here. There was actually one that was close to the site that I couldn't get enough data that made me comfortable making a determination. So the closest one actually is on the site, which is comp number 1, which is on page 13. And I found sales of properties, bedrooms, baths, but I also found 2 sales of properties that had resales, sales and resales, which is the way I really like to do it, is sales, resales. Sometimes I get triples. So there were 2 here that indicated that the property values are going up. The third one, which is on Brody Trail, between 20 and 24 went up 12.8%. The last one on Goldview actually went up 10.2%. The second one, which is the closest after that one, is actually in Waynesville. And all of these basically are Southern Concrete Materials concrete plants. So it's the same group that's doing the development that they already have these. So it's a pretty good comp because then you don't have any kind of outliers. They have same management practices, things like that. As you can see on comp 2, I've got a number of sales resales. So they're all going up, and they range from 2016. One of the comps up to 24. Third comp is in Mills River, which is a little more semi-rural. All of those also went up, and those are all within 1.19 miles of the concrete plant. The fourth one, which is in Hendersonville on Shepherd Street, I found 2 sales resales, but also found some other data. All of those were within 0.35 miles. So all of them were not too far away from the concrete plants. Start getting outside of about 5 miles and start wondering whether it's something that's going on. So that's basically the methodology that I used to make a determination.
And again, your ultimate conclusions are there on the first page, the 2 bullet points in paragraph 7 of the first page of the affidavit.
Oh, you can give me a copy of that.
Oh, well,
That's probably the same. 7.
it is your conclusion based on your study and expertise that the project will not be detrimental to the public welfare or injurious to property or public improvements in the neighborhood. Is that correct?
That's correct.
And that the project will not cause or have adverse or negative property value impacts on surrounding properties.
That's correct.
Those are the questions I have, Mr. Chairman.
Questions? One question.
Yes, sir.
Of the 4 comparable studies, you're looking at, if I read these right and listen to you properly, you're just saying the property values have gone up over the period of time, depending upon when the sale occurred and the resale occurred.
Yes.
Isn't it important to know, how well did they go up, or in comparison to properties that are not with a concrete plant?
It would be, if you've got sales and resales, then they're right there in the proximity of the concrete site. If you're talking about saying, well, this property is within close proximity, this one's not, is there damage that way or a value? I don't think it has any bearing on it because your best comps are the ones that sell resale.
But if the overall market outside of the concrete plant area
Right.
is inflating as well,
Right.
isn't it the question of whether the houses around the concrete plant are inflating equally or more or less?
You make a good point because, and I must apologize, it's not in this report because MLS is kind of finicky sometimes, so I couldn't get some of the information when I submitted the report. But since then, what I did was I actually looked at each one of these sites and compared it to a, for instance, the number 1, which is where the site is, the average annual change was an average of 11.5% on those 2 comps that I had data on. Within 5 miles of the quarry site, the increase over 5 years was 10.46. And in the county, the average was 9.87.
So
Within
it's
5 miles.
comparable.
Yes.
Okay, thank you.
And it was the same to all of them.
So, John, quickly, based on what you heard from the people who want standing and their perceptions that their properties are going to lose value, based on your professional opinion, do you agree or disagree with that?
With their property values going
Up or down, with the neighbors and their concerns?
There's no data that I could find that would indicate that they would go down. That's what you asked. Because what I did was, I did a half a mile, 3 miles, and 5 miles radius. And I was looking for the closed price average and the closed price median to see if there was to basically support what I just said. Within a half a mile, there were only 3 listings. Rather that you could say anything, so that wasn't anything. Within 1 mile, the increase was 11.85%. Within 3 miles, it was 9.33. And within 5 miles, it was 10.21. So they're going within those, if you want to call them concentric rings. And it indicates to me 10.97, which is within 1 mile, the property values have no effect. You go further out, and other things start creeping in, like French Broad River on one side and things like that. So that's why I kind of ran it that way to see if there was going to be a huge variance, because that would have led me down a different path.
Okay, thank you.
Other questions, thoughts? Hearing none. Thank you, John. Anything else before we,
In the last 5 minutes, I will just leave that space.
give us back some of our day?
Yes.
Sounds good. Their floor is open for a motion to continue this case to a date certain.
I make a motion to continue this case to next month.
Let's do that. Is there a second? No discussion. All those in favor, please say aye.
Aye.
Any opposed, nay? That motion passes. Thank you very much.
And as a logistical thing, I'm assuming we're still up, meaning we won't be bumped. Because we're in the middle of it.
No, I hear you. We will try to juggle that and give you a heads up.
Right
As
to decide later.
yes, we are not sure, so we will let you know.
It's a solid
Okay.
We don't like.
How about a
Sounds
definite
like a
maybe?
lawyer talk there. All right.
You're right. We like to continue straight forward from that. Yes, ma'am.
Yeah,
There's a
The
public
next
notification.
meeting will, our meetings are always the second Wednesday of every month. So this next meeting will be specifically February 12th, and it will start at 12 o'clock. And it should be at the Board of Commissioners Chambers, which is at 200 College Street. So that,
It's on the third floor there.
yeah, it would be on the third floor where the commissioners hold their meeting.
Yeah, bring them. Absolutely.
Yes, if anybody wants to speak, that would be the day that they would be given an opportunity to speak. Well, it usually happens after the plaintiff or after the applicant, basically finishes their initial presentation, then the chair will open the hearing for witness statements, and then witnesses can make statements. And then, and so, yes, it will be in, and then the respondent or the applicant will have an opportunity to respond to those statements.
That's the process, but we don't know the answer because it may take a
depends.
certain amount of time to do that.
But I can't tell you between 12 and 4 on the 12th when specifically we will be hearing this matter. And as you could probably tell from today, things get kind of weird sometimes. So,
When this case is going, we won't get a chance to say anything.
yeah, they will finish their case in chief. Then we will open that up to witness testimony or external witness testimony.
May I ask another question?
Please.
So when we come back, then those of us who've already spoken, we can speak again.
Oh, yeah.
Yes, you only were testifying regarding your standing application. You did not give any testimony regarding the case in chief. So that's very different.
And can we bring experts to that meeting?
They wouldn't have, you could bring them, they could speak on their own, but you wouldn't be able to introduce
And you can't cross.
any evidence or anything.
Yeah, it's more the witness
Public
statement
comment.
at that, since you are not basically a litigant in this case, you are basically able to present your personal knowledge and things like that.
Legal representation at that meeting?
You can,
Yes,
but they
not
would not be
separate.
able to intervene and participate in the hearing.
This won't forward, we're just.
We,
that's all.
the standing matter is over. If you would, yeah, you would need to wait until the board renders a decision. Ma'am, did you have a question?
If I had already put in to be a witness and speak today, do I need to do that again?
No,
We'll have you on file for next.
no, you're all ready to go.
Craig, you offered a community meeting, right? Or no?
Yes,
So get with Craig on a community meeting.
I will, but we actually asked last community meeting for data and we have not received that data that we asked for. So we will go there again, but we have asked, one of our neighbors, mine and Chris, I live beside Chris, 1,000 feet away. He asked for a printout or a data of all the work that they've done so we can prove that it won't affect our air, won't affect our water, and we've heard nothing.
That's
So
the
we
best
can
way.
go.
That's the best way to go about it, though. The next community meeting, attend that, and then
Yeah, we'll go again.
and then
don't worry.
public comment at the hearing next month, and then they have an opportunity to respond to you. There's not a back and forth Q&A. though.
Opportunity too is the question.
An opportunity. They don't have to respond. That's right.
Well,
That's right.
it would be nice to have, one person gather the questions and email them to either myself or to a representative of Southern Concrete so that we can come prepared with the answers.
To the community
So
meeting.
if you would do that, that would facilitate a discussion.
We provided those at the last meeting. but we'll
In
have them
terms of,
We'll
in
have-
writing, rather than free flowing, just
give us the homework assignment in advance.
So it sounds like you need to elect a secretary to gather all the questions and then forward it on to Mr. Justice. I think that's what I hear the process.
And you need to do it in a bigger area. because-
Well, I may push it off to Warren or somebody to coordinate the logistics of it, but if you will just send me, you can reach me. I'm at the Van Winkle Law Firm. You can Google me. You can find my email address, and just one of you will just send me the list of questions. I'll forward them to the client, and then we'll coordinate a meeting.
I'm asking how you're going to notify people of that meeting, because you did it in a really small area.
Use your secretary.
So we're gonna, whoever's communicating with me will figure out where it makes sense to have the meeting, and then I'll look for y'all to coordinate who attends, rather than us trying to figure out who should attend.
Yeah.
That works. Yeah.
I make a motion to adjourn.
There's a motion to adjourn. Any discussion on the motion? Second. All those in favor, please say aye.
Aye.
Any opposed, nay? That motion passes. Thank you, we're adjourned.